So after 1 o'clock, so who's for chair? Oh, that's right.
Well, your show, Keith. So I
Yes, it's Keith.
Our chair in the absence of-
Well, I will go ahead and call this training meeting, for lack of a better word, to order. And David, would you call the roll?
Yeah.
All right, Mr. Hinckley.
Here.
Mr. Kennedy.
Here.
Mr. Platt. Here. Mr. Thine.
Here.
Ms. Hanny. He's there.
Jeff.
Yes.
Ms. Hanny.
Oh, yes, thanks.
I'm here.
Everybody's here. Vice Chair.
Thank you. And with that, I don't know exactly what order we're going in, but I'm assuming that David's passing the mantle of command off to some of the legal staff.
So actually, I'm going to go first.
I was saying,
Okay.
David's actually up first.
Okay.
So, okay, I guess, I don't know where you want me to stand or whatever. All right, well, so I just put a really short presentation together, kind of on the history of our zoning and comprehensive plan. And then just some other kind of basic information. And then the legal staff will get into the more depth on some of the fun stuff. Clicking doesn't have.
Do you want me to sit there in advance of David?
And I guess while you're working on that,
Just a second, I think I got it now.
and what's your preference for questions?
No questions. What I have for face value, no.
Just a pause.
Whatever, whenever you want to do
Okay.
questions, I don't care, so.
All right.
And I guess just another plenary question.
Do you want me to quit?
Sure.
This is open to the public via either Zoom or.
It's a closed meeting. No, it's open to the public.
Yeah, it's not an executive
Everything we
session,
do is
it's open.
public.
It's not, I'm
Anything-
just wondering, we don't have any.
We don't do executive sessions, so.
No, but nor do we know who else. We have the Zoom people here, but then it's also just on the YouTube channel. Is that
Correct.
Correct.
Correct, yes.
And there's no public comment during what constitutes a work session
Correct.
normally. So,
Right.
That's
Yeah.
exactly
Yeah.
where I was going, just so who all are we on? We got unlimited number of audience, but the discussion here is just a fun stuff. Exactly. Okay, thank you.
Okay. All right, so just brief overview. I'm going to go over the history of planning and zoning in Albany County, talk about the land use management system, comprehensive plan, zoning resolution. How the comprehensive plan and zoning regulations work together. What is a comprehensive plan? What is zoning? And this is going to be very basic. Planning and zoning commission duties, and then some planning terminology. We'll just throw out there and if there's any questions. So the first adopted, well, I don't know if this is the first adopted regulations, but the adopted regulations that I could find records of in my office was the land use management system. They're adopted in 1982. To go back, and I think maybe I talked about it before, I think in the late 70s, about the time I was born, they tried to adopt zoning in this county and it failed. So in 1982, they adopted the land use management system. And this document was kind of a hybrid of a comprehensive plan and regulations. So it had some policies that the county had adopted, as well as it included performance-based land use regulations, and then also subdivision regulations, all in one document. So it's kind of like a unified development code almost, but it included some of the comprehensive plan stuff. When I say the land use regulations, the permitting was done by performance measures. It was, you met certain criteria and then they would allow that permit to be approved. So zoning regulations did not exist at this time.
Yeah, you can just turn the clock back a little bit for us. Where, from the state point of view, when did they first even allow any kind of land use regulation? Is that a,
That I don't know. I mean, I think subdivisions regulations have been around for a long time, but other than that, I'm not sure on that. So like I said, I didn't go back too far, so I started when I was born and then
Well, I know it's been controversial as long as I've been alive. I got a few years on you, but that's where it's never got started. I'm sorry.
Right.
In Albany County, we're talking about here.
Yeah. So I think there was actually some challenges to some of the regulations at one point, but they all passed muster, I guess, for the Supreme Court. But in 1996, there was a case called Ford versus the Board of County Commissioners of Converse County. Somebody was basically challenged their regulatory system, which I believe was similar to our regulatory system. And what came out of this case was comprehensive plans are prerequisite for the adoption of zoning, which is kind of standard. Comprehensive plans are not regulatory. Zoning is the only way authorized by state statute to regulate land in Wyoming. And then with that, the Ford decision basically voided the LUMS, or the land use management system that we had, and this prompted the development of comprehensive plan and zoning regulations, as well as our subdivision regulations. All in 1997, we got those all done. That's kind of amazing, right? So here's our first comprehensive plan. You can see I included the table of contents on this robust, ginormous document. It was all of 12 pages. That was our comprehensive plan. It was created in response to that decision. I put two questions. Was there robust public input? And was it really comprehensive? I would say probably not. But so in 2006, we began the process of updating that comprehensive plan, or really creating a real comprehensive plan. This included some robust public engagement. The public engagement part, the meetings and such, lasted over a year. There was a citizen advisory committee and a technical advisory committee that were created that ended up being just one committee. I'm not sure exactly at what point that happened, but this was kind of the steering committee of the group that came up with the comprehensive plan. And there was a series of public meetings, stakeholder interviews, work sessions with planning and zoning board of county commissioners, and they did a telephone survey of 500 households, which was a pretty good chunk of folks or whatever that weighed in on our comprehensive plan. So each of the chapters includes kind of background conditions, objectives, implementation strategies, and actions.
David, did that just precede your arrival on the scene here?
So when it was adopted in 2008, I was here when it was adopted. Like, I've been here like a month or two.
So you didn't write it. Who actually did the writing?
So Winston Associates, I believe. I think they were a planning firm out of Boulder, if I'm correct. I think so. They did that. There were some other folks that were involved. There was a statistical place that was involved that did the surveys and some of that. But I think it was Winston Associates that kind of ran that project. So what's inside? So the comprehensive plan identified, the first thing that the comprehensive plan does is determine the vision of a county. I've heard a vision kind of described as, so if you come back, so this is your vision, this is where you want to be, and you take so many steps back, and it's this is what you want it to be, and then you make goals and actions to get to that vision. And so the vision statement is something they do whole meetings just on the vision statement to determine what is Albany County's vision. And then there was 12 chapters. I think there's 9 or 10. In comprehensive plans, each of the issues is typically called an element, but the element would also be a chapter. So it looks at land use, obviously, agriculture, housing, just public services, infrastructure, transportation, those types of things. I think some of those are kind of mixed in the same categories. We have recreation, I believe, open space and recreation is one of the chapters. So those are also called elements. So if you ever hear someone say, well, this comprehensive plan element, it's usually just a chapter that focuses on a subject. And then again, each of those chapters includes the background information, actions, strategies, objectives. And it's kind of interesting because like, depends on whose plan you're looking at, you know, there's goals and there's strategies and there's actions, and each one of them kind of defines that differently. So you just look at your plan and you kind of determine what those mean. So regulatory and non-regulatory strategies are also in action. So, you know, we talk a lot about, okay, this is going to be applied in our regulations, or how do we apply this to permits that are coming through? There's a lot of things in a comprehensive plan that have nothing to do with regulation. There's lots of non-regulatory things. Like in our economic development chapter, there's a number of suggestions in there for programs and things that can be implemented by the government to help meet that vision, but in a non-regulatory way. So here, now we're going to go back again to pre-1997 land use. So like I said, zoning was considered in the late 1970s, but didn't get any traction. Land use management system in 1982, the Ford decision in 1996. And then after they developed their comprehensive plan and adopted that in 1997, they then adopted our regulations, our zoning regulations. So yay for zoning resolution in the county, right? The zoning, so this is where my rub was when I came here, is our zoning was based on the assessor's land use classification, so no map. What you're looking at is our zoning. So every time that there was a property that came up, we had to dig through a Word document to determine what the zoning was. And the zoning was based on how the taxes were classified for that property.
And that presents a huge problem out, especially where it's agricultural for tax purposes, because the house and the barn and all that is taxed as residential. So
Sure, yeah. That's why you see, when you see our map, you'll see kind of what happened because of that, yeah. So
this is gonna jump between you and our legal folks. I'm fascinated by your statement that the Ford decision said you couldn't zone unless you had a plan first. Is that what I heard you say?
it said that, yeah, before zoning regulations were implemented, you had to have a comprehensive plan.
And then did it say the zoning had to be based on the comprehensive plan? Because
No, I don't think it.
you just said you had to have one.
Just said you had to have one.
That interesting. So
Yeah.
the comp plan could be going this way and the zoning could be going this way without any reference between.
Yeah.
Interesting. Okay. And that's what we did in Albany County, it sounds like, because this thing wasn't based on comp plan at all.
Yeah.
Is that fair?
Well, this was not, no,
Okay.
no, absolutely, just on current land use according to the assessor, so.
Which is where we were run into a lot of issues, is that we had land use regulations and zoning regulations in place prior to the comp plan. And they've been updated to incorporate the sections of the comp plan that have been brought in, but they were not derived initially from the comp plan.
And a second question, this is something that City Planning Director Keeney explained to me, at least at the city, that the word comp plan means more than just that document. In the city's case, they have a streets master plan.
Sure.
They have and in the case of the county, we have the comp plan. We also have the cash profit protection plan.
Yes.
Are all of those kind of considered comp plan for?
Yeah, for this purpose, I don't know, I guess you can answer.
Statutorily, they're all considered land use plans.
So that'd be determined before. So,
Yeah.
and so we probably shouldn't say Ford said you have to have a comp plan. It said you had to have land use plans. Is
But
that-
they are used interchangeably
Yeah, that's-
throughout Wyoming.
So,
And yeah.
so for us, we have a comp plan, which we call the comp plan. And then we have these other plans that have different names. They're not called the comp plan. And when we refer to them, we're not talking about the comp plan, but they are treated under the statute like a comprehensive plan.
So besides those two, what else do we have that stands at that legal level of land use plan?
All the ones David has on the website.
Yeah, anything that we would use that statute for notice and everything, the comp plan statute, that's what I would say would be considered a comp plan.
I mean, just kind of like through, I'm thinking for one, is that where our codes for
those are the only two plans
Where
that,
does
yeah.
come from?
Yeah, so a lot of the code is based on that from our zoning, is the Casper Aquifer Protection Plan, so.
Okay, I guess I'm just asking for some examples. As for Jennifer, I don't know the list, but.
That's all that we've
Rattle
rattled
off.
off. Yeah, so, and then I think you brought up in an email, since we're talking about this, the natural resource plan. So that will not be considered a comp plan. It's actually, the natural resource plan document is developed under a different statute. And so it will not go through the same procedure, and it's for a different purpose. It's more for governing bodies to deal with the federal government and what, what citizens can do on their private property.
And then the growth area management plan is another one that has the word plan.
That would be a comp plan.
That would be one
Yes,
of
that would go under that category, yes.
Okay.
Because the one that they're just developing.
Yeah.
That one specifically in the development of it is that they are using it as a joint plan with the intention of implementing joint or regulation into the zoning regulations after that's done. They're going to provide suggestions, then the county will have to go through the process to implement the parts of it that they want.
I mean, we'll have to see how that goes, but it's on that same track. And that's, of course, that this connection between land use management plans, is that the right term, Matt?
Land use plan.
Land use plans and zoning is an important one. So that's what I'm trying to get clear on what that is. So thank you.
All right. Okay, so now we're getting up to our zoning resolution. So zoning resolution was adopted in 2015. This was created after the comprehensive plan was adopted. The Planning and Zoning Commission created a zoning advisory committee. So this was a group of mostly public, I think there was one Planning and Zoning Commission member on there. But they're all appointed by the Planning and Zoning Commission. Basically, it was whoever wanted to be on there. So, Planning and Zoning Commission reviewed and approved the plan or the zoning, and then the Board of County Commissioners reviewed it and denied it, sent it back to the Planning and Zoning Commission. So there's more to the story than that. So there was this naive planner that was taking this through the process. And he did it at the same time as the Casper Aquifer regulations. And so one of them got kind of pushed to the side, which was the zoning, while the other one got handled. And then the other one, basically zoning, went back to the Planning and Zoning Commission after things had calmed down. They reviewed it, maybe changed, tweaked a few things, and then sent it back, and it got approved. So, but that was a rookie error there.
I remember that hearing.
Yeah, because everything was all tied together at that meeting, and it looked like everybody hated everything. So, but not quite.
So pulling out of that, the issues with the comp plan, were there some that kind of stood out that the P and Z and County Commission were at different places on?
Not really. Like there was really minimal items in the zoning resolution that there was trouble with at the county commissioners level. It was just the fact that it was kind of, because it was grouped with the Casper Aquifer stuff, let's not deal with this right now. Let's send it back to planning and zoning while we deal with the Casper Aquifer. So we really didn't get a whole lot of direction other than, no, it's denied, send it back. That's what I remember. I'd have to go look in the documents to see, but that's kind of what I remember. I remember the things that we kind of discussed were really minimal. The people that discussed them I remember one of them was home businesses. It's like, well, we don't want home businesses. It's like, okay. And then when we went back around, the person that complained about it was ended up on the board, and it was like, fine, we just changed a couple words. It was great, so, but yeah, so not a whole lot that came from that. There wasn't a disconnect at that point. So.
And then this map that we're looking at, is that just a mapping of the tax assessment, or did they?
Yes, it is.
Okay.
That is what that is. And that's why If I gave you a different perspective, maybe more out in the county, you just have these little dots of commercial or whatever, residential in the middle of these big islands of green, or places of green, oceans of green, I guess.
Maybe this map's generalized.
No.
This is specific. Yeah, this is specific to all the properties or whatever.
So you just mentioned some small infoldings of residential or whatever.
Yeah,
That's
so
all- those are all shown or not shown? That's what I meant by generalized.
They're shown.
they're shown. Yes, they're shown.
And this is obviously 6 to 7 years after the fact now. Can it be assumed that this map is accurate, or are there errors embedded in it?
I laughed because we've had several cases over the last 2 years where it was more of a technical correction, because
Sure.
when it was done, there were initially some assumptions made about some properties, whether they were residential or commercial, and that might or might not have been, because otherwise you'd have to ground truth every property in the
Right.
entire county. And we've dealt with several pretty routine matters like that, rezoning a property where it fit the use that it had for some time, maybe, well, prior to the zoning resolution.
And that's why I'm asking,
Yeah.
because that represents a huge amount of information.
Right. So to say it's inaccurate, it's not inaccurate. We adopted it.
I'm
Yeah.
asking, can we assume that it is accurate?
Yes, I mean, this is what's adopted. It is what it is.
Yes, okay.
So,
Yeah,
And isn't it true, David, that you update it when there's a land use change that gets passed by the commissioners?
we do, yeah.
So it's constantly accurate, or
Yes.
the intention is it's supposed to be
Yeah,
constantly
and-
accurate.
Actually, this document that you see here is kind of the static document. We actually have a zoning map now that's interactive or whatever, and that one is totally accurate. That's everything that happens, Joe makes sure gets done, so. But may I, since we're talking about this, let me just kind of point out how, I don't know if it's the flaws or the way that we created this was based on that document, right? The assessor's document. If it was based on the comprehensive plan, we would have looked at some of these areas and said, okay, this is what it is, this is what we want to see happen. We would have used zoning to be a tool to implement the comprehensive plan. And that didn't really happen because we just went by what we already had, right? So instead of zoning something like, okay, this is next to the city, maybe this is a good place to have housing, or look, it's all between this. It's eventually all of this is going to be residential. We could have zoned it that to implement the comprehensive plan, because that's what it's asking us to do. And I'm not saying those specific things is what the comp plan wants us to do, but we did start out with that in mind, as looking at our zoning and looking at our comp plan and trying to zone according to it. But then we changed the way we wanted to do it. It was more like, I guess the philosophy was that we'll leave everything as it is, but we'll use the comp plan for future changes, which that's something we'll be talking about, so a little bit more. But anyways, that was one of the flaws, I think, in how this went about. I just think that we should have used the comp plan more at that time to really plan for the future, instead of making someone come in and say, well, where can I do this? And like, when you say, well, you can do it a lot of places if you can get a zone change, instead of saying, these are the areas that you can do them because we've zoned these for those purposes. That wasn't really the philosophy that we took at the time, but that's my perspective at least.
yeah, and some of the confusion in the public's mind is this is separate from how the assessor treats a property, whether it's commercial, industrial, agricultural, or residential. And that is part of what adds to some public confusion as to what an allowable use is.
Sure, yeah. I mean, for example, someone comes in and wants to, it's like, I want to subdivide this, and it's like, okay, well, let's see what the zoning is like. Well, it's assessed as is residential. I'm pretty sure the zoning is residential. Then I get on there and it's like, no, it's actually agricultural, because that's what we're zoning it, and it's different from what it's being taxed for. I mean, the assessor taxes it for the highest and best use of the property. And so,
With the exception of ag.
yeah, right.
Yeah.
Right.
So
anyways.
so that connection to the tax rolls was made in 1997. And then since then, the taxes have gone their direction and zoning has got its direction.
Yes.
Correct.
Okay.
Yeah.
So,
Next slide.
and to what extent, if you know, was that a conscious decision to just, I guess what I mean, the zoning map, regardless of where it came from, represents a statement. This is how we want it to be. So in that sense, it's a inherently very conservative document. It just says, we like things the way they are.
Right.
And now they will be that way until we change them. Is that a fair characterization, that whether by default or expressly, that was the policy decision that was made?
I don't think it was a decision of we like things how they are. I think it was we're not taking the time and we don't have the time to go through and zone it according to, like, we want growth in these areas, so we're gonna allow for it here. It was just an effective means to implement the new zoning that was required after Ford throughout the county as a whole, and to make sure, because in Albany County, we don't have any areas that are not zoned. There are some counties that don't have areas, that they have areas that are not zoned, and Albany County didn't do that. So it wasn't we intend to keep it this way forever. It was this is what it is right now, and we're gonna go from there.
But
You're talking 1997?
well, yeah, and then this map is a map of 1997. I guess the point, we all know that a lot of important decisions are made by default, and I'm suggesting this is one of those. So I guess to your point, Jennifer, is the legal status of those maps in any way changed? Whether it had been a hard fought, we want houses here and bugs and bunnies over there, versus us just saying, hey, we like it the way it is. We legally aren't, or are those any different?
If legally, no, because our zoning resolutions, there is no provision in state statute for a zoning map. So the zoning map is a function of our regulations. So, and our regulation says that the zoning map is the official map, which is accurate because it is the map David maintains and it is the official map. And it also, in the zoning map section, I think it's section 4 of chapter 3, it says that something about the date that it was printed or something like that. And it's just before the zoning's change section. So then after talking through it with Matt and David, Matt talked to David this morning, and then I talked to a friend who's also a civil attorney in Sublette County today. And with that language, with the date that it's printed and the fact that reading our regulations as a whole and the specific language of the zoning change section, which is the zoning map is section 4 and zoning change is section 5, it is legally read that zoning map changes once a land use change has passed through the Board of County Commissioners, which is what David has been doing within the planning office. So the map is always current. Like it says in section 4, that is the map. And it is amended when the zoning change procedures are followed and approved by the commissioners.
Okay, I guess I'm not.
Because to read it differently would.
What sense does zoning make without a map? Maybe it's just conceptually, I'm having trouble with it. Listening to you, it sounds like you could have zoning and define what R1 and C2 is, but no map.
But yeah, because
You could tie it to legal
just-
descriptions
yeah,
and not
you-
have it on a map.
Uh-huh.
The map makes it a visual representation that it's easy to
Because-
find.
Because just like my deed, I could describe every parcel in the county, just like the assessor did earlier, except every legal description in the county would have zoning tied to it, and you would need a map.
Oh, yeah, but I think that's a distinction with no particular difference, whether you describe it visually or describe it by meets and bounds. The point is you have described in some manner or other the footprint of
Yeah.
R1C.
Yeah.
Okay, that's fine. So my question is though, can you have zoning that doesn't have a a footprint of some kind of an identification of where it falls, whether you do it in colors and a map or just do it on narrative.
No,
I
because
think by definition, that's what zoning is.
that's what zoning, if it didn't fall in that, it would be an unzoned area and not fall into one of those categories, and we don't have that in Albany
So when
County.
you say there's no state requirement for a map, you mean there's no state requirement for a colored diagram. But there is obviously a tacit requirement for a description of parcels somehow. Gotta know where these things fall. Right? I mean, I guess I'm not understanding when you say there's no state requirement for a map. Are you meaning no state requirement for a physical graphical representation?
Correct.
Okay, but there is a state requirement for a where.
In all things land use, it has to be specifically described, whether by meets and bounds or lots and blocks.
Okay.
So, yes, it requires a specific description of the land.
So the zoning that was created included a description of the land, that goes clear back to 97, and a discussion of what can take place on that described parcel. Like, is that correct? And then,
Say that again.
okay, well, I'm just saying,
What is it you're trying to get at ultimately? Because I think we're missing the
Well, it
ultimate
does-
question you're getting.
Okay, well, what I'm getting at, and it's something that we have discussed and we'll discuss later on when it comes to a potential change in our zoning regulation. The way I'm understanding this, and the way I perhaps mistakenly am reading the law is when we establish zoning, we say on section 2, with or without a picture, you are allowed to build 5-acre lots.
Yeah, so each zone, described in some way has a number of these.
And if you want to change those parameters, either whether it's 5-acre lots or 4.5-acre lots, or we want to change it to the bottom half of the section, top half of the section, both of those constitute a change in the zoning regulation.
No,
And why is that not the case?
because you have a provision within your zoning resolution to allow for zoning change. If it was interpreted the way you interpret it, you are then giving, in the legal world, it's called the Chevron deference. You can't take an ambiguous provision within the zoning maps that says that, I don't know what part it is that you are reading within the zoning map section to say that it can't be changed. But you can't take this zoning map section and read it to say that forever and always defines the zoning of a parcel in exclusion to the zoning change provision that is directly below it within the same regulation. You have a very specific provision for a change within the zoning change section of section 5 that overrides any ambiguity that you might be seeing within section 4 that wouldn't allow a zoning change without a regulation change. Does that make sense?
Yeah. No, and I think my thick head has figured that out. And so we'll come back to this, but my suggestion, I love your word ambiguity, is that we, as a regulation change, resolve that ambiguity. That's getting us off the thread of your story. But let's.
Well, and I agree with you. And I think maybe to clarify, after we got your email, I was talking to Matt, and maybe we add something within the zoning map section when we are updating the regulations as a whole that says, as may be updated from time to time by the planning director. Knowing that it can't be updated without going through a zoning change because there's nothing else that would allow the map to change.
Okay, no, my suggestion is that we simply write that saying a change in the map is an amendment to the zoning resolution. That would resolve this in a different way.
No. That makes this an administrative nightmare.
If you did that, you get rid of the entire.
You get rid of
you
the
would also
entire
delete
section
all of
5.
Section 5, and if that's So there's nothing in state statute that controls a zoning change from one parcel being zoned in this district to another district. How that is handled is entirely up to a resolution. So if that is ultimately what you want, put forward that.
Yeah, no,
But
that,
there is no law which states that such a change from one parcel to another constitutes a full amendment to the resolution or regulation itself, which then requires the promulgation of a new rule through the Administrative Procedure Act.
well,
It's entirely up to the
I
regulation.
don't know what you mean by a full. Let's say we wanted to change from 5 acre minimum in a rural residential to 4.5. Would that be a change in the zoning regulation?
Correct.
Yes.
That's a promulgation of a new rule, which requires then that you have to follow the Administrative Procedures Act for promulgation of rules. And the time and the cost on a staff level to do that, as opposed to the provisions, following the provisions for zoning change within the existing resolution is, it's a far bigger process and far more time consuming. So my suggestion would be, if you have an issue with the zoning change provisions, let's work on those rather than doing a full promulgated rule change every time there's a application for a zoning change.
Like what happened with the APOZ regulation amendments.
Right, we changed that within the promulgated rules change because it affected more than one parcel. When you're talking about a zoning change, it only affects one parcel, whatever is being applied for. And
That's fine. We could drop this thread for now and get on with your story. And I thank you for the interruption, but I would like to come back to this as a issue of, do we want to change the regulations? That's not what we're here to do today. I'm just trying to understand the regulations. So thank you for that.
Whoever to skip this one, maybe talk about it. So, okay, so there's two kind of main part. Well, there's, I don't know, I think I was going to talk about zoning a little bit. So updates to,
you need me to go back one?
let me see where my thread is here. So, okay, so as a part of the zoning regulations, you've got your map portion and you've got your standards, right? And within the standards, you have a land use table. So one of the things that we did to our what we changed from 1997 to 2015 was we took what you see on the left is a list of uses and just put it into a table. It was just more of a change to make it easier to determine. And so that's another portion. So I hear the terms land use and I hear the term zoning all the time. And they're actually two different things. Zoning is the actual, as we were talking about, geographic boundary. And then land use are the different uses of land that can occur in a particular zone. So just to kind of clarify that a little bit. Also, so within the zoning, the new zoning regulations, we also changed the zoning change process a bit, modified the organization, and then updated some of the standards. So also in a zone, you also have, other than the land use itself, you have standards like lot size or how much frontage you have to have, setbacks on a property, those types of things as well. So you can move forward. So comprehensive plan and zoning. So what is a comp plan? Comp plan, this is out of our comp plan. The comprehensive plan is a county guide for making land use, community development, and capital improvement decisions. So it's the official policy for the future of land use and development. And it's the foundation. I included that graphic that's kind of blurry, but the comprehensive plan is your foundation, right? I don't know if you guys have been out in West Laramie and there's a foundation out there where next to like the McDonald's or whatever in that area, there's nothing on it. It's worthless. It's useless, right? So until you get something built on it, it's not of much value. And that's where when you adopt zoning, you're using that foundation to adopt zoning, you use that foundation to, on this it has roads and utilities, determine where those types of things go. As well as The comprehensive plan will also direct you to create other plans that are part of that as well. Like ours recommends, well, it says it recommends using the CAP plan, obviously, and also recommends creating like a master plan, trails and open space master plan, some of these other things that you can do, and then you further that. But the comp plan is the foundation. It's the policies, it's the big picture, it's where we want to go. And then you get to the zoning and other regulations that kind of get you to where you want to go. It builds that structure to make that foundation worth something. And it has no regulatory authority. And then, so what is zoning? It's a tool to implement the comp plan. It divides jurisdiction into zones or zoning districts. I think I've hit most of this stuff. Includes standards like lot size, setbacks, etc. Allows, so with uses, land uses, there's 3 types of kind of uses that we categorize them. Prohibited means you can't do that use, right? Conditionally allowed, so conditional uses, those are not, they're not allowed uses, but they're not disallowed, but you don't have to approve them, but you can, and you can also attach conditions to them, obviously in the name there. And then there's allowed uses that if you're in that zoning, you can automatically do that with whatever permitting is, like the zoning certificate to do it. So next.
So to later on today, we'll have a specific example of that, with my understanding it, like I want to open up a daycare in a residential, then that chart is what tells me that that's an allowable use with a special.
That's a conditional use.
Yes.
Correct. Okay. Thank you.
Let's see. I think we talked about all that. So what are your duties? There's 2 in statute. Your duties are kind of outlined as a planning and zoning commission to prepare and amend comprehensive plan and certify the plan to the Board of County Commissioners. That includes the Albany County Comprehensive Plan and the Casper Protection Plan. So I think we kind of discussed this already. Prepare recommendations to effectuate the planning and zoning purposes and certifies recommendations to the Board of County Commissioners. So you are now, that's basically looking at other things other than the comp plan. You're looking at zoning regulations, which you can create and send to them, subdivision regulations, which you can create or amend and send to them, and then the applications that we do, zoning changes, additional uses, tower permits, variances, wind farm applications, and subdivision applications.
Go back. Just go back. What? Okay. Just small diversion. That business about certifying. At some point, I remember somebody was going to ask for a AG's opinion on whether that was required. Did that ever happen, or is that something you guys can share with us? I just remember somebody was going to try to run that thing down.
Are you talking about whether it has to go to planning and zoning and then to the board to get approved?
Yeah.
Like regulations? I don't know.
So when statute requires that planning and zoning certify a recommendation to the board, the question that we were dealing with was whether, because the language of the statute is fairly specific in that it says approve or deny the recommendation of the board. And so the question was, like with the aquifer, the APOZ amendments, where there were substantial changes made at the commissioner's level, whether that had to go back to planning and zoning for review and certification again, or whether it didn't. And ultimately, the recommendation from our office after conversations was that it does not have to. And so, and there's a current appeal pending on that. So we'll wait to see what the court says.
Okay, thank you.
May I ask a question?
Certainly.
Thank you. This is Mr. Thine. I'm trying to work my way through these intricacies, and I do better with an example. So I'm going to pick something that most of us are familiar with, which was the Tumbleweed gas station. And obviously, from what I understood, the aquifer protection plan said, well, you can't have a gas station there. And then, or was that a conditional use to have a gas station?
It was a grandfathered use. That gas station had been there since, I believe, the sixties. So the gas station was there before there was even zoning regulation in the county.
Got you. So if I wanted to put one there now,
Correct,
I couldn't.
correct.
Ah,
So like the Tumbleweed gas station falls under our regulations, our zoning resolution is a non-conforming use.
right.
And Matt will discuss that as part of his presentation.
Okay. That's good. Thank you.
You're welcome.
I'm totally with Jeff on, things make more sense. You've got a concrete example in front of you. So to spare us this discussion at Mr. Watson's expense, he's come forward with a request for zoning change that we'll take up at our regular meeting. But couldn't you get the same place by just calling it grandfathered? So
It's a different property. So he's created a boundary line adjustment. And so the zoning doesn't follow the boundary line adjustment. It stops, that delineation doesn't change when he adds more property to that.
his shop is currently on a piece of ground that isn't zoned for commercial.
No, it is.
Oh, okay, well then maybe
Isn't it, Joe?
I
Yeah, one, where his shop is at, I think is zoned commercial. And he added some that was in the residential.
He did a boundary line adjustment to make that parcel bigger.
Okay, all right, well then
Yeah.
I'm getting ahead of myself.
Okay.
Sorry, okay, good.
All right, I just brought up a few different terms. You'll hear it. Zoning district or zone, same thing. This is your basic, this is your residential, commercial, industrial. So this is what you'll see on the map. That's what you saw in all the colors on the map. An overlay zone is our aquifer protection overlay zone where it's delineated, right? And it's over the top of, it's overlaid over the top of the base zoning. Those are used with, and they have special standards for that area. They could be lessened, they could be more. We actually have a neighborhood conservation overlay zone, which is over smaller lotted areas that allows them to have less standards because they existed. It's almost like a grandfathered zone, just to say that they don't have to, apply the new standards going into the future, I guess. And then density. So density is like the number of housing units per acre. And then lot size. So you'll see both those terms in our subdivision. Lot size is actual size of, so you have a minimum lot size, and that means you cannot go less than, if it's 2 acres, you can't go less than 2 acres. If there's a 2 acre density, that means that all of them would have to, you add them up and get the average, right? So there's could be some that are less than 2 acres if that was, depending on what the lot size could be or whatever. So that's the difference. Kind of density is more of an average, and then lot size is the actual size of the lot. Spot zoning. This is when, you're in a big area that's all residential and somebody wants to put a little industrial property in the middle of it that's just out of place, doesn't belong there. That's kind of what spot zoning is. Those are basically illegal. You're not supposed to do that. Now the one thing with spot zoning is like, just because there's residential and stuff all over, if you're at an intersection and it makes sense to have kind of commercial node, that may not necessarily be considered spot zoning. But if it's in the kind of out of place in the middle of a residential zone, it might not.
So I'm listening carefully to the words. You said illegal, you don't mean that. There's no law against spot zoning, that's just poor practice.
It is actually, it's
It's actually
judicially
statute.
created law. It's not statutory.
I've heard that was illegal.
It is
It is statute.
illegal. Oh, it is?
Isn't it?
I don't
Maybe
know
not.
if it's in a
Generally, no, generally it's a pretty common court doctrine where if you zone something industrial in the middle of a residential neighborhood, that will be an illegal exercise of zoning.
That's not written down someplace, just it's a case law or something.
Written down in case law, yeah.
Okay, but that's how it's usually true. We don't have
I probably shouldn't have said illegal because I
No,
didn't.
no, I think
know.
that's very important. I'm
Well, it's not
carefully. So-
Okay, it's not criminal.
No, but some.
But it's on- it's on law.
Throwing you in jail.
But someone, if we were, I mean, this is about us, if we, the county, were to zone something that people thought it was objectionable under the concept of spot zoning, they might have a cause of action.
They might,
Okay.
It's very
It's-
narrowly defined.
yeah,
It's
it
not
has to
like,
be pretty egregious.
yes,
Like I really, you come back to an industrial parcel in the middle of residential. neighborhoods.
A cement plant next to my house on South 11th.
Yeah, yeah.
Right.
Like
and
they-
when the cement plant is coming in when it wasn't already
Yeah.
there. Like, your neighborhood's already there, now we're gonna put a cement plant in the middle, as opposed to like Cheyenne, where they have housing all around the refineries, because that's the way Cheyenne grew.
Like, we're gonna do a new feedlot in the middle of the tree district.
Okay. Thank you.
Washington Park, there's good grass there.
And then leapfrog development, that's the other term that I threw in there. So when you have a developed area, you have all of your services. If you develop another area that there's, miles in between it with nothing, and now you're putting in this little development, that's leapfrog development. A lot of, especially in the city, that when it's leapfrog development, when you're not in the position to hook up into services, and it's not close to other development. Even in the county, that's still the same thing. It's just kind of out in the middle of nowhere. So yeah, those are the things. Any questions that haven't been asked?
David, I have this question, and I think it's a good example. So you have a residential area, and somebody decides to drill an oil well in the middle, which is an industrial use. That would be one of those spot situations.
Answer?
Sort of, but like mineral rights are preempted.
Yes.
So,
Mineral right, that rules the roost.
yeah. At least in Wyoming.
Yeah.
But yeah, if it was some other industrial use and that would be the case.
Maura has her hand.
Okay, so it's fairly intricate. I get this impression there's like overlapping or subordinate and superior considerations when in planning and zoning, when somebody came before us and said, "Oh, I want to change this," we'd have to carefully work through, first of all, is that a legal thing, or is not, I won't say illegal, but not normally done. I mean, some of them seem real obvious to me, but then some of them seem pretty subtle.
Yeah, and so I guess to your point about kind of knowing the legal structure, statutes trump everything in the county. So the county gets all of its authority by what the state says it can do. And so the state says it can zone, except for when it comes to minerals. We can't affect those types of projects. So yeah, I mean, it comes down to your legal structure. So.
Okay. Yeah, I don't think we're going to have many of these, but I just kind of was thinking of the extremes. That always helps me kind of put a context to it.
If it's on my property, maybe I'd want them to drill a well, because
Right? You might have some surface rights involved there.
Well, yeah, if you have the mineral rights, I can see you very much want that.
Yeah, an example of that, if I've understood our past conversations correctly, that's extremely relevant, is the Stats University. Now, is that state statute says that they're outside of planning and zoning, is that right?
Any state and federal land
Is exempted.
is exempted, yeah. We've done that specifically in our zoning. I guess I don't know what's the statute, so.
I see the statute probably. The state doesn't like you to mess with their stuff.
Yeah, and
City likes to fight with lobbies.
Right.
we'll get to county. The state says what you can and can't do, and
Right.
the state trumps. I have no trouble with that. I just think,
Yeah.
where does that affect us? So if the university wants to do something, they don't have to come to planning and zoning, to the county or.
No, but the university's an exception too, because with some really limited exceptions, they can't purchase property without the permission of the legislature.
Mhm.
So, they're not gonna go out and grab a parcel over here without somebody a lot further up the chain.
And that is actually a really interesting question, Mr. Hinckley, but I think that from my research and what I prepared for today, regulation of state property is not expressly prohibited by statute, but jurisdictionally, I think it functionally is.
Elaborate on that a little bit for us non-lawyers.
So yeah, they are the higher entity than we are, and commands go down the chain, not up.
Just the logic of it, that if the state of Wyoming that wanted to put in a subdivision, then they wouldn't have to come and ask us because they're in the state of Wyoming.
Yeah,
That's an interesting question because there's a mess going on in Teton County right now where the state wants to put in a housing development on the highway department property there, and Teton County denied it. And so we'll find out whose horse is.
Oh, okay. Stay tuned.
and my guess would be the states.
Yeah.
Yeah.
Laura does still have her.
Okay.
Yeah.
Laura, go ahead.
Thank you. David, thanks for the presentation. I know you thought it was going to be short, but it didn't turn out that way, huh? I just have a question to go back to the zoning maps and the creation of them. And that you said at that time, the decision was made to zone things essentially the way that they were. But then there was the addition of these other residential zoning categories. And so I wonder if you can explain what went on then in some of these areas, like 7 Mile area, for example. There are lots that are smaller, they pre-existed, they're smaller than they should be for small lot residential or rural residential, but you see the whole area zoned as rural residential, as though the thought was, we're gonna zone it this way because even though we have these small lots out there, we don't think that's generally the way we want to go based on the comp plan in this area. So is that kind of how those things got zoned?
Yeah, I mean, it's trying to recollect. I know that what we did when we did do the zoning, we looked at lot sizes a lot, and we zoned things either small lot residential or rural residential. We do have the urban residential, but we didn't zone anything urban residential at that time. And if we have it all rural residential out there, it may have been something that was addressed in the comp plan, but honestly, I can't remember. I know that we did look at lot size to determine if it was small lot or rural residential.
Okay, thanks for answering that. That's all I have. Thanks.
I just wanted to follow up on that now. So going forward, we start with the plan, right? With that's kind of the county's vision of what they want to happen now, and then we take the plan. When somebody says, "Oh, I want to change zoning or modify things," do we refer back to the plan as our starting point in that discussion?
So we used to, but with the interpretation of the state statutes and the changes that have happened, now we are not using a comp plan in those decisions. But I can tell you in most jurisdictions outside of Wyoming, that's what you do with the zoning change. You look at the comp plan and what they have, and then you don't necessarily base it. Well, I mean, you use that for part of your decision making, I should say.
Right.
But we don't not doing that.
What do we do?
So we use what is in the regulations, and I know Jennifer and Matt can kind of go. I think they're going to go into this a little bit more depth. But we just look at what is in our regulations. We look at some of the same things. We're looking at patterns of development, whether it fits in that specific area. What are the impacts on traffic? What are the impacts going to be on water quality? Those are the things that are within the regulations. And so we look at those types of things. And really what the comp plan did when we created it was to look at those areas that are growth efficient, and we would base our decisions off those areas that we define as growth efficient and what we do and what we don't. But like I said, the statutes have changed since then. So
Okay, thank you.
So just a comment on Mara's question, or Commissioner Hanning's question. If I'm understanding this correctly, there are lots and lots of non-conforming lot sizes out there. And I know.
oh, absolutely. Yeah.
And that's
Centennial, the whole town is non-conforming. So.
And that's not a problem. Is that fair? I mean, that just is.
Because Matt will talk about them. Those are those non-conforming uses that existed prior to the zoning. So we can't do anything about them now. We can just not do those things going forward.
Most of our problems were created probably before zoning was ever.
That's why some people thought we ought to have some.
Right.
But yeah, I'm just thinking that's unlike a non-conforming use that if it falls out of that use for a requisite amount of time, then it disappears. A lot size.
Can't really force someone
It's
to
never gonna, no.
buy their property,
No.
their neighbor's property, and make it a conforming lot.
Yeah, okay, so those just stay non-conforming uses forever.
Yeah.
Yes.
Yeah, okay, thank you.
And Commissioner Hinckley, to go back to your question before about when the state enacted zoning and subdivisions and all of that, when I look at the statute for the authority being granted to the county commissioners to be able to regulate zoning, it looks like it initially was established in 1959. The separate real estate subdivision section of the same statute looks like it began in 1975.
What was your distinction there between the two?
The real
59 for zoning general
Yeah.
and 75.
75 for subdivision.
Interesting.
So,
Just a slight tangent here. There was a time when the zoning was being hotly debated in Fremont County back in my dim memories. And this one got up and said, planners are the spawn of the devil. And so that's some idea of the level of animosity this has generated over the generations. I think we're past that and we kind of like some of the planners now. But still are home.
David, as a really practical matter, does the zoning map also exist in interactive form, or is it?
Yes, it's an interactive.
Okay.
Yep, we've got it on our website. So.
All right, so you can look at it, zoom in and zoom out.
Yeah, the problem is you can find the assessor's map and you can find ours on the website. And I've given the information to the assessor, but it's not on their website. I wish they would put it on their map just because there's still going to be confusion as long as that map is separate from our map. So, but yeah, ours is on, if you get on the planning website or planning web page, just scroll down that front page. It's right there. You can click on it and check it out. So sometimes it's not working. I got on there yesterday and I was like, oh, nothing's showing up. So, but this morning it did. All right, let's turn it over to these guys. No more questions.
okay, I'm setting up the new screen share here. Hold on.
Okay.
Don't save because I did not change anything on purpose. I know. I'm like, sorry, David. But now I can't see any of my things. Wait.
Can you just share the screen here?
Yeah, but I just got to click the right one.
Oh, yeah, you do it up there, right?
Yeah. Let's see. The way do I select this invalid? Of course it is. Why does it go to both screens?
It does do that to me too. So now go back to the thing and it should be pop up.
Back in here. Can I just do this one?
Sure.
Well, that's not it.
Yeah, hit that one, hit that, do what you did a minute ago to make it go. Hit the beginning.
It's not, it's on this one. It doesn't like me. Just a minute. Maybe it'll work it now. Oh,
So move the, just move it over to that screen.
it's not, it's whatever it's selecting. Hold on.
Yeah, get rid of everything you can and then close it all down.
Why don't we take about a 5 minute?
I was saying, can we
break?
take a 5-minute break and
Let
refill
them
waters
worry about
and,
that Without us staring at them.
sorry,
and
thank
then
you.
No, that's quite all right.
I'm sure
That way we don't have to take a.
There's no
another
pressure
break later.
when this happens.
No pressure, it's all
They were
fine.
better with eyeballing.
I know.
You pause the
I think you have to do the first.
I remember.
I do,
when
I was just
Windows
closing all
95
these other
just
windows.
Worked so poorly.
But I should be able to
I had a presentation about 300 people and I decided
do this.
print transparencies for overhead on the slides. And then we lost.
And now if I
go.
Then you were reduced to just.
Jennifer, I'm going to pause the recording until you're ready.
Thank you. There we go. I don't know why it's big over here.
Because
There, I fixed it.
all the emails were like on the screen and stuff.
I know.
Oh, gosh.
Sorry.
Dave, if you guys are taking a break, do you want to mute your microphone until you come back online?
That's the one that she hit the tree, Dave. Wasn't me.
Here, I'll mute you from here.
Thank you.
Oh, sorry.
Dave, that little tree is far too close to the mute button.
We'll start the recording over there. Okay. Just want to make sure you got it. Okay.
Don't start yet, Matt. Dave's got to run clear back across the street.
Hey, man, if you and Joe at one time or another physically been basically everywhere out in the county,
I've been all over the county. I don't know if I've been on every road up north, but I've been on quite a few of them up there. There may be a few I haven't hit around here, but yeah. Joe's only hasn't been here long enough to get.
I haven't been up north really at all.
Yeah, so yeah, when I first moved here, I went with like our addressing coordinator or wastewater inspections when we go way up north. And so visited a lot of places up there and visited a lot of good folks up there. So heard some stories. And
How do the folks in the very far north end of the county feel more connected to Cheyenne than Laramie, or do you have any sense of that?
I don't think there's
Excuse me, Casper.
We lived in some cases.
Yeah, I think you have a lot of people that kind of are in that area, go up to Wheatland or whatever, but I've never heard anybody really going to Casper, but it's not like I've met a whole ton of people up there either, so.
When somebody
It's
says
kind of so
Toltec
big.
is what you have to, do you think Mexico or do you think North? Let's say Toltec.
Oh, really?
Okay, David, can you unmute us?
We're on mute.
Oh, we're on mute? Okay. Well, members of the Planning and Zoning Commission, my name is Matt Ayers and here with Jennifer Coran, and we're Deputy Albany County Attorneys. So can you go to the next slide, please? So that's just an overview of our presentation. I will just be discussing the first part, general land use law in the state of Wyoming. And then Jennifer will get into more of the Planning and Zoning Commission specifically and the legal obligations that go along with being a member thereof. Next slide, please. So as David mentioned, counties are pretty limited in their authority. It's only what is specifically delegated to the county by the legislature through state statute. However, I would say that planning and zoning on regulation of land use is the most significant grant of authority that has been given to counties. And just as a general rule, you cannot exercise that authority in contravention to what state statute says, but there are examples where statute will allow zoning regulations to be more restrictive. And just off the top of my head, subdivisions, you can go above there, or you can go above the standards for subdivisions that are in state statute, but you can't go below. Similar for wind energy conversion system permits. Next slide, please, David.
Do you want that one?
Yeah, so these are just the list of relevant statutes, which are grants of authority or provide standards to the County Planning and Zoning Commission and the county commissioners for the regulation of land use. Okay, so 185201, this is the general grant of authority which enables counties to regulate land use. And that is the underlying portion is what every zoning action has to be pursuant to. The promotion of public health, safety, morals, and general welfare. That is broad, but if you try to act beyond those core subjects, there's a good chance it'll get struck down. And as you can see regulation and restriction comes down to buildings and structures, and then also the use of land. But there are restrictions tied to this.
What's your last bullet?
Oh, yeah, so in the unincorporated,
Should have said unincorporated.
unincorporated, yeah, so, and that is the statutory language except for the I. Just broken down into bullet format.
That's you don't reach into the cities, is that the idea?
Yeah, and that is actually in that same statute. David, can you go to the next one, please? It lays out 4 restrictions for which the county cannot regulate, which includes regulation within a municipality, incorporated, to be specific. You cannot regulate the extraction or production of mineral resources. Furthermore, there are, under the subdivision regulation, or under the subdivision regulation statutes, there are certain subdivisions which have to be exempt from county regulation. They made sure to include that you cannot get around to those exemptions by trying to regulate them through minimum lot sizes. And then there's also certain private schools that have to meet certain conditions, just as an example. So, sort of a quasi-restriction is the non-conforming use. A non-conforming use has to have been a pre-existing use, which was lawful when it was established, and then which later becomes non-compliant with zoning regulations due to the inaction of those zoning regulations. Basically, under statute, these uses have to be allowed to continue. So you cannot prohibit the continuation of a non-conforming use if it was lawful at the time that it was put into use. However, there are caveats. If they try to alter or make additions to existing structures, that will essentially take that use out of non-conforming status and therefore put it into unlawful or violation of the zoning regulations. Furthermore, if a use is discontinued for a certain amount of time, as is defined by the zoning regulations, that use will then have to conform with the regulations which are current. Another important restriction is that the county cannot regulate or eliminate livestock grazing on private or county land. So ag and oil are significantly protected. And that's just our example under the Albany County zoning regulation. You cannot expand or alter non-conforming structures. Repairs, however, are permitted, but that repair has to be less than 50% of the aggregate value of the structure or building, which is then determined by the county assessor. And what's that?
Go ahead. So is there any limitation on the definition of discontinued? I mean, could someone conceivably shorten that time to, is the court going to determine whether that was capricious to say you can't stop this use for a week? Or
I know that from law school, courts have found that if you try and argue a discontinuation based off of a use which is itself a seasonal use, that's not going to fly. I think it really just comes down to what we consider an abandonment of the use.
Okay.
You could probably look at similar standards for like abandonment of easement, where it has to be non-use coupled with an indication that you are in fact relinquishing that status.
On Tumbleweed, there was a specific, it was like 24 months of non-use or something. There was a a specific time frame that was quoted. Is that-
I think,
That
I think there's
We
a,
actually changed that.
uh-huh,
And it
after
was-
tumbleweed.
It was 24 before tumbleweed, and then after that had gone through, we changed that to 12 months.
Mhm.
Is my recollection.
I think that's correct.
So we did go further than what you're remembering. Somewhere along the line, and put a time frame on it.
Well, yeah, and I think it really comes down to state statute doesn't define
Oh, I
what
see.
non-use
Yeah.
is
Okay,
or
that was it.
discontinuation of use.
That was the county.
So that, but yeah, I think if it were to get challenged, 2 days might be,
My guess is they'd look at the reasonable nature, like if you were selling a business, a restaurant, for example, because that's just what came to mind at first. If you sell a restaurant and somebody has to come in and upgrade equipment and, remodel and hire staff and retrain and do whatever, what's a reasonable time frame? It might take you 6 months. I think you have to allow for business transition, even if you're continuing the same use. Sometimes it takes a long time for the new owner to get it up to where they want to open it. And I don't know what that timeline looks like, but I think a week is far too short.
Well, I think my confusion was Albany County regulation versus state statute, which is what you're talking about. So at the regulation level, a county can choose to define that, what they mean by
within reason,
uses,
yeah.
Yeah.
within reason. Gotcha.
Yeah,
Thank you.
absolutely. Okay, so going, I suppose, to the objects of zoning itself, uses are permitted through zoning certificates. Under state statute, it is unlawful to essentially erect or change structures or change the use of land without a zoning, without first obtaining a zoning certificate. And this has pretty hefty violation, or has pretty hefty penalties. Each day's continuation of violation is a separate offense. And it is $750 a day up to that a court can award a penalty for. So under the zoning resolution, we generally do this through application for a zoning certificate, which it depends on how exactly that's approved. There are some zoning certificates which David handles by himself because they're just straightforward things. Everything that you handle, of course, obviously requires review and recommendation by the Planning and Zoning Commission, and then ultimately approval or denial by the commissioners. So we got into this during rail tie, or at least the appeal thereof. But conditional use permits fit the definition of zoning certificates. They're just being called something different. And obviously, any sort of conditional use permit is going to require review and approval. And they can be called different things. That doesn't change the fundamental nature of them. So in just a few examples in our regulations, we have sign permits, both outdoor signs. There's another
On-premise signs?
on-premise signs. Those
On-premise and
require,
off-premise signs, yeah.
okay, on-premise and off-premise signs, those require permits. Towers require permits. And of course, wind energy conversion systems require permits. And this is an example of what one looks like. So, if we could. Okay, so moving to the comprehensive plan, which of course has been a heavily discussed subject as of late. This is how they're defined in statute. And interestingly enough, statute and case law both recognize that generally as a prerequisite to zoning, you have to adopt a comprehensive plan. That is a blanket rule, I believe, across the entire country. And obviously it's codified in Wyoming statute that all local governments shall adopt a local land use plan within their jurisdiction. That didn't quite happen in Albany County. I'm not sure when this statutory provision was enacted, But you do have to have a local land use plan. And that plan is defined by statute as written statements of land, which gives the policies, visions, goals, objectives of future land use. They provide an explanation of the methods for implementation of the plan. However, they shall not require any provisions for zoning. So as statute defines it, the plan is just that. It's a visionary document that says where a community would like to go with land use. Zoning, however, is the law that implements that visionary document. And that's the regulatory control. And tells you exactly what you can and cannot do. Thank you. So this is 98301. This was enacted in, I think
July of 21.
July of 21 and became effective July 1st of 20.
It was enacted during the legislative session. It was during the April, maybe March or April of 21 is when it was approved, and then it was effective July 1 of 21.
Okay. So this is new. And to an extent, this did codify a few decades of case law on the subject. But it spells out that local land use plans may guide local governments in adopting or amending their zoning regulations. However, those plans are not to be confused with zoning regulations, and that zoning regulations have the force and effect of law. Generally, they're to be implemented, so a local our zoning regulations will control over a land use plan in the case of conflict, and that no local government shall require a land use or development to be consistent with a land use plan unless the applicable provisions of the land use plan have been incorporated into the zoning regulations. There is some question as to what exactly incorporate means. Based off of my research and Jennifer's research, and specifically the case out of Sweetwater County, which was Laughter, the county commissioners of Sweetwater, the Supreme Court used the term engraft, which is something beyond just incorporation by reference. It is taking those provisions and just moving it over into the comprehensive plan. And obviously that will necessitate some language change. Regulations regulations or law should not use terms like should or it is desired. It has to use terms such as shall or shall not. And then that's further demonstrated by section F. Nothing in this article shall allow any local government to use a local land use plan as authority to deny or restrict a permissible land use or physical development, which is not itself restricted or prohibited under the regulations. Next one, please. So this is not to say that the land use plan or that the comprehensive plan is not valuable. It's incredibly valuable. It was the result of multiple community stakeholders coming together and implementing a future for Laramie, or a future vision for Laramie and Albany County. And ideally, it would guide how the zoning regulations look. And it still can. Part of your power and authority as this board is to give recommendations of zoning regulation amendments to the Board of County Commissioners for consideration. There is nothing that prohibits taking the provisions of the comprehensive plan and implementing those into a regulatory network, or framework, should I say. How can you go back?
Okay, can we dial back to 98301 Romanet II?
Yeah.
Hold on, I just printed it. I'll go get it.
It was on the slide. Yeah, that one right there.
I'll-
Okay, let's go. Okay, so this what still seems to me as an ambiguity, but maybe you could talk me out of it. Romanet II
Yeah.
looks to me to refer to a land use or physical development, like a subdivision or a cement plant, or whatever it is, not zoning itself. Now, does this Sweetwater case speak to that? I mean, you seem to be reading that Romanet saying, no local government shall require that zoning be consistent with local land use plan. That isn't quite what it says to one reading. See the distinction I'm making?
I'll just say that, so that was kind of what I brought up earlier is there's zoning and then there's land use, right? And I think that's kind of what your point is land use is mentioned here, but zoning is not.
Yeah, it's, quoting Ms. Grant, it should be noted that zoning change and subdivision permit application are two separate and distinct processes, each requiring our own considerations and findings. So is Romanet II talking about, say, a subdivision application, a school, a specific land use or physical development, or is it talking about changes of zoning?
It's what permits the land use, the change in zoning.
Right, but it's one step removed from that statement, as one might interpret it. But
Okay, land use or physical development.
no local government shall require that a land use or physical development. I guess I'm suggesting a possible reading of that would be, no local government shall require that you have 5-acre lots based on their comp plan. It has to be in
Correct,
the zone.
because that is in the zoning regulation.
Right. But that's different than the zoning regulation itself, where nobody's in front of you saying, I want to do the happy acre subdivision. They're simply saying, I want my land to be zoned rural residential. That isn't a specific land use or physical development argument. Now, perhaps the Sweetwater case made that distinction.
Yeah, well, I will direct you back to paragraph E. And also Ford versus Converse County, what's it, Asphalt Specialties versus Laramie County. The land comprehensive plan does not have the force and effect of law. It's not a regulatory document. Actually, David, can you go 2 slides forward?
But asphalt specialties we keep hearing about, it's completely inapt. They didn't have any zoning, right?
No, they didn't.
No, they applied the land use plan.
Right, but they
Yeah.
didn't have any zoning. You
Yes.
have zoning.
We do.
Read the first sentence of.
We do have zoning.
On 8-301, it says,
But-
comp plans can be used to amend zoning. Which will be.
Correct, the zoning resolution.
Yes. Sorry.
So, but then you have to go through that administrative regulatory change to amend your zoning resolution.
Yes.
And also, yeah, so this is the executive summary of the comprehensive plan. The Albany County Comprehensive Plan has been adopted pursuant to, well, this enables the adoption of a comprehensive plan, which states that the Planning and Zoning Commission may prepare and amend, The comprehensive plan serves as a guide for future land use and development in Albany County. It is advisory rather than regulatory in nature. So your regulations need to say what you can and can't do. This advises how we should go about that in the future.
Okay, it still seems to me that there's a difference. I'm creating regulation. Now, if I conceptualize zoning as the creation of regulation,
Yeah,
then surely a change in zoning is a identical activity. So now I'm to a change in zoning is the creation of regulation.
Zoning
No.
regulation is this. It is this document that has been adopted by the Board of County Commissioners. A change of an individual zoning of an individual parcel is not a change of zoning regulation. Is not, like I cannot make that clearer. Under our current regulations,
Okay. under our current regulations. What I'm
Correct.
suggesting is one might want to change our existing regulations
Certainly.
to recognize a change in zoning as the conceptual legal equivalent of zoning.
Why?
That seems like a real obvious thing, but
No,
those are the same action.
Vern, I don't follow what you're saying at all.
Well,
I don't either.
I do, because it creates a bureaucratic nightmare, because that means that when you want to make a zoning change, you now have to go in and change the actual regulation every time
Correct.
someone seeks a zoning change. And
That's
it's untenable because of the legal requirements for the Administrative Procedures Act to change the zoning regulation. Because we would spend from start to finish probably close to 6 months then for every zoning change.
Good.
So, I think we get stuck on the whole regulation thing. So in my opinion, when we're doing a zoning change and when we're creating the zoning, regulations, there's two different processes or ways we're doing it. And so when we create a regulation or a policy or whatever, grand, all-encompassing policy and regulations, when the Board of County Commissioners takes action, they're taking action as a legislative body, right? So they're acting as lawmakers and they approve it. Now, when we do a zoning change, and I found this in some law book I have in my office or whatever, we're actually doing more of not necessarily administrative process, but a quasi judicial process. So when we go through this process, we've already made this grand policy action that was taking place. Now we're implementing a smaller action that is guided by that bigger action, if that makes sense. So we're taking a specific piece of property to do a zone change, and then we go through a process and it becomes quasi judicial because it's not changing the entire document. It's just changing something that's already defined and how you change it within the document. I don't think I'm explaining it the way I wanted to explain it, but so I guess to dumb it down, so a legislative action is more of a policy setting. You're setting the policy, you're setting the rules. Quasi judicial action is more of a policy action and you're applying the rules. And that's what we're doing when we change the zoning. We're applying the rules that have already been created through policy setting. That's all I got to say.
And I think
I don't know if that helps anything, but
makes sense.
but I read about it this morning. So.
There you go. And Commissioner Hinkley, I think if there's an underlying concern about the way zoning changes are currently handled, then the way to address that would be changing a one-time change to the zoning regulation with regard to zoning changes to address whatever it is your underlying concern is, rather than having to change the zoning resolution every time a zoning change was presented to this commission.
Okay, I understand that the objection to what I'm positing here for sake of discussion is that it would be a huge burden and it would be crazy to do that. It would take 6 months to do each one. Let's set all that aside and simply try to follow the thread of the logic. We develop it as Planning Director Gersh laid out for us quite eloquently. We build a foundation that's called the comprehensive plan. We use the comprehensive plan to create zoning.
But we didn't.
But we should, and we could choose to if we wanted to, okay? And in fact, we should, I think is the pitch that we heard from our planning director, that was a mistake to have been so cavalier in our creation of zoning. In any case, it is the zoning. It is in the zoning regulation. It's what's referred to as the official zoning maps in section 4. So here we are. Now, it would seem to me, as just the logic is, if you're changing the zoning, you're in exactly the same intellectual place as when you created the zoning in the first place. And you would use exactly the same tools to address the change in zoning as you used to create the zone. That just seems only sensible. It's just a little bitty version of the same thing. Otherwise, you end up in a situation where I could pass the zoning regulation with all of the appropriate authority of the county commissioners. Then I could immediately go and completely unravel that sweater piece by piece, as though I was just making small changes like approving a conditional use permit. That strikes me as illogical and arguably contrary to the Administrative Procedures Act. That's my point. And so a fix, one way or the other, it's ambiguous. We wouldn't be having this discussion. We could fix that by changing our regulation to say what we really mean it to say. It would seem to me that what we want it to say is that we will address zoning changes in the same manner we addressed zoning, or should have addressed zoning, i.e. building upon the foundation of the comp plan. That's where I'm kept coming from on this philosophically. And what I'm hearing is bad idea because it's so hard. That's not an institutional argument, but that's not illegal.
I have a solution for you. So what, what applies to the can you think of anything that applies from the comprehensive plan besides the priority growth areas to what you would consider for a zoning change?
Oh, no, I'm not.
No. I mean, honestly,
I don't have a specific thing in the comp.
Because I think that's generally the basis for what should be allowed is what's laid out by the priority growth areas. Yeah. So you take those, create overlay zones in the zoning resolution. And you incorporate those standards instead of may or should or large lot development. Well, you define what large lot development is. So that's actually a workable regulation, not a visionary perspective document. And then you say within these overlay zones, that's all that's allowed. There are still the zones underneath, what it's developed as, but it'll allow someone to go from, say, ag to rural residential. And then that's your standard. Because, I mean, yeah, you're absolutely correct that it happened backwards in Albany County of how it should have. As far as use of the plan. The plan was developed well afterwards. I think that was a decision based off of necessity. They had a moratorium. There's a case, Krauthamel, the Albany County Commissioners, in which moratorium got denied. So they had to get a zoning resolution in place really quick in order to have any control whatsoever. Under basic principles of administrative law, we have defined in our resolution as it is now that it's not an amendment to the resolution when you do a zoning change. If people were locked in to a specific district for entirety, you would get takings claims left and right. We would be hiring outside counsel. It would be expensive. But I'm not trying to get into, I suppose, those logistical reasons. Focusing on the conceptual reason, under the law, we have defined that it is not. There is nothing in the Administrative Procedure Act that I have found, and I've dug on this, that suggests that such a zoning change, which from my understanding is a consistent tool that's in place across all of the counties in Wyoming for those due process and private property right reasons, which that is considered a full-on legislative regulatory event. So that is a tool that you can use. Take the comprehensive plan, put it into regulation. That will give you a permissible, or that will allow you to define what zoning changes can be in the future.
So you're offering that there are other ways to skin this cat. Fair. I'm a little sensitive to words like full blown. I mean, are there legal precedents for how full blown do they have to be to count? I'm looking at section 4, is it, that says the official zoning maps are part of this regulation. Now we are changing the official zoning maps, right? So like, how can that not be a change in the regulation? We are
Because
changing section 4.
it doesn't say in the zoning map section that once it is set, it is forever and always that. That specific language in 4 says, otherwise, there would be no reason to have the language displaying the date printed. The language of displaying the date printed implies that that zoning map can change pursuant to the zoning change provisions in section 5. And when it is reprinted, that becomes the most current zoning map.
But that's true of anything in the regulation. It's the law until we change it. But let's say I have a piece of ground, it's zoned rural residential, and I want to put in 4-acre lots. Okay, there's 2 ways I could accomplish that. I could come and change the regulation to say rural residential will allow 4-acre lots instead of the 5 that's in there now. Or I could say, let's change the map and call it small lot residential. Either of those gets me to the same place. Either one requires a change in the zoning regulation.
But they don't get you to the same place, because when you change it in the regulation, you have changed it for all future applicants rather than for that individual parcel. And that, to me, that's the distinction. And
I agree.
Yeah.
Laura's got her hand up, so if you.
Okay, I'm sorry.
Well, at some point, if you want to take her question.
Oh, yeah.
I have I can't really participate in this amazing conversation because I need to interrupt to tell you I have to leave to go get a child from school. But I guess I'm hearing a lot of resistance to the idea that Commissioner Hinckley has put forward as the hopes for a quick fix to what is perceived as a problem, that we can't look to the comprehensive plan, even in its general guidance, as the statute or as the zoning resolution is currently written, even though we're being instructed to ignore that section, we're told to look to the comprehensive plan for general guidance. And I appreciate the alternative path that Mr. Ayers has put forward. I think that because that's how we're using these priority growth areas. I mean, that's what I'm doing when I'm looking at assessing a zone change request, or I guess really their land use change requests, because they're all labeled LUC. So I guess the terminology is confusing between zoning and land use, where people are applying for land use changes that result in a zone change. And we look to the comp plan at these priority growth areas to guide us on what in the vision was acceptable growth for this area, even though there may be non-conforming lot sizes and non-conforming uses within an area. We're generally guided by these priority growth areas. And that is, to me, the part of the comprehensive plan that if we have to do this on grafting, that to me is the part that I go to look at. And if there is a way to do this with overlay zones, I would be in support of that as a solution to look at. And now I will go and listen on my phone while I drive in and go pick up a kid. And if you're still going when I come back, I'll come back on.
thanks, Maura.
Thank you. Yeah, I'm prepared to move on, but I'm still unconvinced that we can proceed. And if someone wants to bring forward a suggestion for a change in the regulation, how does one do that?
You type up an amendment,
Will do. Thank you.
and we can certainly help you with that.
Okay, I appreciate that.
Mr. Gersh, can you?
Which way?
Next slide. Okay, so these are just some general case laws for, in case you would like to do some dry legal reading, and I'm sure all of your infinite free time. Next slide, please, Mr. Gersh. So subdivisions, they are controlled by a separate article to an extent under state statute. Really, that one that I showed you earlier, 185201, that gives you all of the authority that you would need to regulate subdivisions. However, the legislature made it a little more specific in in Article 3 of Title 8, Chapter 5. So subdivision is the creation or division of a lot or a unit of land for sale, essentially. Mr. Gersh. However, once again, no person shall sell land subject to subdivision regulations, record a plat, or commence construction of a subdivision without first obtaining a permit. The Albany County zoning resolution defines what a subdivision is. It has to be single parcels split into 3 or more parcels. State statute allows you to go, I suppose, up to 5 without it being considered a subdivision. Ours is kept it at 3. Maybe something to look at. Ultimately, the policy choices rest with the commission. 185306 is a long, dense list of subdivision requirements and minimum standards. It depends on the size of the subdivision, whether it's a small subdivision or I suppose a regular subdivision, or there's even large lot subdivisions. And just as a quick reference, the Albany County Planning and Subdivision Regulations is a separate document to the zoning resolution. There is interplay between the two of them. They could easily be considered as a single document, but that's, I believe, just how things have progressed historically, that at one point became a separate document. So, and under that, generally, we have small and regular subdivision regulations. I will say that upon the appeals we've been doing, application of the planning and subdivision regulations can become rather complicated. You kind of have to consider them as a whole and understand the interplay of all of the different regulations, and then figure out which parts fit into a specific subdivision. Mr. Gersh. So these are your statutory exemptions, which of course we cannot try to regulate through kind of a back channel. So family subdivisions are prohibited from county regulations. However, the subdivision has to be between immediate family members. That's what statute defines as an immediate family member. And whoever is the owner of the parcel initially, the grantor, generally has to hold that lot for 10 years prior to the division, and then the grantee has to then hold it for 5 years after the division in order for it to be exempt from regulations. If either of those holding requirements are violated, then you will then become subject to the regulations. So also you have eminent domain, court order, sale of the state, sale to the state of Wyoming, that you cannot regulate those through subdivision regulations. Division of agricultural lands that will remain agricultural lands, cemeteries, utility parcels. And then of course there are parcels where each of the parcels 35 plus acres. Is that correct, David?
Yeah.
The result, the divided parcels.
Yeah, 35 plus acres.
Mhm.
Less lots, yeah.
Unless, of course, there's 11 plus subdivided acres, and the initial land was greater than 140. So, subdivision, this is an interesting area just because of the evolution of the state statute. 3412, Article 1 lays out the platting provision. So every time you subdivide, you have to record a plat in the land records. And it gives those requirements. So it used to be that subdivisions within 1 mile of a town or city, incorporated town or city, had to be jointly approved. It gave the city an opportunity to also make a decision on it. Any subdivision proposal. Ultimately, in 2009, the legislature amended that and said that if the county, they said if they have a comprehensive plan, then the town or city only has an opportunity for review and comment. Their opinion onto it is not binding upon the county. However, the statute does allow municipalities to enter into joint voluntary agreements with the county for regulations within the city. Okay, thank you.
It's like that's where we're headed, I think.
Yeah, that's what it looks like.
With this growth management plan. Thank you.
Yeah, that's the intention of it.
Yeah. Because, I mean, coordination can be helpful for growth. So variances. Variances are not covered by statute necessarily, but they are a universally used zoning tool. They allow specific deviations from the regulations, which are generally non-offensive to the regulation in a particular circumstance. It's a case-by-case decision. They're generally avoided to grant injustice, individual and unique cases in which adherence to the regulations would result in difficulties or unnecessary hardship. It's important that that hardship cannot be self-imposed and must be a result of the nature of the property itself. And further, it generally cannot detriment the objectives of zoning. So our zoning regulations have a specific list of findings which are standards and findings which must be made in order to grant a variance. So just briefly, this is really where zoning gets litigious. So zoning that essentially goes too far can result in regulatory takings. Under the Fifth Amendment, the takings clause, nor shall private property be taken for public use without just compensation. Similarly, Wyoming Constitution, Article 1, Section 33, private property shall not be taken or damaged for public or private use without just compensation. Obviously, any sort of land use regulation or zoning has impacts upon private life and private individuals, and also economic impacts. It can change property values. It can prevent someone from maybe from pursuing what might be the most lucrative use of the land. It defines use, density, and also it does have direct financial costs to individuals. That is to be expected. Historically, or can you go to the next slide? So historically, land use regulations were generally understood by the courts to be within the purview of the state's police power, which allows the state to protect public health, safety, welfare, and morals. Beginning in I believe, late early 1900s, the concept that that police power can go too far began to develop in federal courts. And it was finally recognized with Pennsylvania Cole v. Mahon in 1922, where a regulatory act which had an extreme diminution on the value of the regulated property was finally found to be a takings, for which, under the takings clause, the government had to pay just compensation. Next slide, please. So these are generally the four categories which takings arguments are analyzed under. You have permanent physical takings and total takings. Those two are takings per se. If either of those occur, the government has to pay just compensation. Exaction and partial takings are the others, and those are more fact-specific inquiries in which takings are less likely to be found, and there's much more room for argument. So with the permanent physical takings, New York City and Loretto passed an ordinance which required apartment owners to offer tenants access to cable. However, it was all through one cable company. The cable company came in, installed cable equipment on Miss Loretto's apartment building without her consent or without her applying for any sort of permit. This was found to be a takings. Any government incursion, no matter the degree, because it was just a cable box on an apartment building, on a private person's property requires compensation if the incursion is not consensual, permanent, and physical. And then we also have total takings, which is a relatively newer concept. And this came out of South Carolina. So there was a the Coastal Council of South Carolina, and they gave setback lines in order to protect beachfronts, or I suppose the riparian sea areas. And Mr. Lucas had purchased property which was previously would allow for a beach house. Then this regulation came in. Under the regulation, he was not allowed to do anything with the property except for stand on it. The United States Supreme Court found that regulation denied all economic use of the property. And whenever that occurs, just compensation is required, regardless of whether you have invested significant amounts of money in the property or not. Then we have exactions. So an exaction is when the governmental body will give a zoning certificate or a permit in exchange for promises. And it generally requires them to surrender some of their property for public use. Usually this is an access easement or forcing them to dedicate a portion of it to the municipality. Under two cases, they've developed a two-pronged test because it can be allowed in certain situations. Under Nolan, which essentially they required or they gave a building permit to a beachfront property owner in California. If he then allowed a public access easement on the beachfront or the shoreline. However, there has to be an essential nexus between the government interest and the condition or exaction. Like they have to line up perfectly. And then there also has to be a rough proportionality based off of the condition or the exaction and the impacts of the development. In Dolan, the rough proportionality was not found because they required for a building permit for Dolan to dedicate a portion of his property to public cycling paths, their argument was that it was because of the traffic impact which the development would have. They said pedestrian development, while yes, it can help alleviate some traffic impacts, that is not directly in line with the impact which the development has, and there's no way that you can measure really either, or the impact or the what would the alleviation would be. Under Coons, the Supreme Court has said that these same analysis applies to fees which have to be paid in lieu of sort of dedications or exactions. Then you have partial takings. The facts don't really matter. This is what most takings analysis is under. It's worth noting that it's hard to get a takings result off of this analysis, but you have to look at the change in property's value. Investment-backed expectations are important under the existing regulations and how those are changed. And then also the character of the regulation itself, things which define sort of the public sphere are given much more deference than things which may be more individualized. So I just wanted to give a brief overview because this is always important to keep in the back of your mind whenever you're looking at new amendments or new regulations. These are the 4 common categories of analysis as developed by the Supreme Court. In somewhat typical fashion, Wyoming's taking the law from the courts is less clear. So the takeaway is that things which I suppose transfer private property to a public use or benefit should give a little bit of pause, because if that is found to be a taking, county has to pay. And just compensation can get quite expensive. At this point, I will sign off to Ms. Kerr.
Mine is far less specific and more general about board's authority and responsibilities as we go through. You'll go to the next slide, please. So statutorily, Planning and Zoning Commission's authority comes from 18.5.202 and 203, which is outlined there, and I'm sure you've all read before. And David went over it, so we could move. Next slide. So in addition to the statutory authority, Planning and Zoning Commission was formed in 1975, and our bylaws have not been updated since 1975. So that likely needs to go on a list. And Matt is going to hand out to you, all of you, a current copy of our 1975 bylaws, and also a copy of Teton County's bylaws, just to give you an example of what other bylaws can look like. Yes.
Is this similar to, would this be considered the same thing as rules and procedures?
So a lot of times there is both bylaws and the procedures, rules and procedures over how the meeting itself is conducted and how the Planning and Zoning Commission conducts its business. So yes, those are generally incorporated into the newer bylaws and things that have happened. And we have done it. We have updated bylaws within our office for numerous of our other boards within the county in the last 2 or 3 years. And this one is on our list to get to as well. But when we do that, we will need suggestions. We can come up with an initial draft based off of what we've done for other county boards and things, and then work with David. And then we would give it to the Planning and Zoning Commission to review and see what you would like added, amended, or changed in there. So in addition to the bylaws, there's the zoning resolution. And then we have our Albany County Planning and Subdivision regulations, which are standard but adopted in the same way. And then the design and construction standards for small wastewater facilities and regulations for permit to construct, install, or modify small wastewater facilities is also a separate document, but enacted as in the same process as the zoning regulations. So as board members, you have fiduciary duties as well as legal obligations and the general duties of care, loyalty, and obedience when you are acting as a board member. So for duty of care, we ask that you are prepared for meetings, that you review the packet David sends out to you prior to the meetings, so that you're familiar with what's in there. If you have general questions of staff, you can always reach out to staff ahead of time to get those questions answered. You want to make sure that when you come to a meeting, you're informed and making sound decisions, and that you attend to your duties with diligence, care, and skill.
So the staff includes you in that?
Yes, generally. Most of the time,
If it's a legal
if
question.
it's a legal question.
But we're welcome to call you.
Oh, sure,
Yeah.
we're available.
Did you
Sometimes-
say, I'm sorry,
But
did you say reach out to staff with general questions?
you can reach out to staff. Well, speaking for our office, and I'm assuming David and Joe, if you have questions, especially where you're new and aren't certain about things, if you have questions about why something is the way it is or where it is in the regulations or whatever, reach out ahead of time and ask those questions. And then if it's something that needs to be addressed during the meeting, that can happen as well.
Well, that's what I'm asking. Are there questions we should not ask in advance?
Um,
If it's one-on-one, it'd probably be fine.
Yeah, if it's one-on-one, I don't know that there's any questions that you should not ask ahead of
So
time.
that's allowed.
Yeah.
Yeah.
All right.
We do screen our calls, so we might not talk to
Yeah, well, I think you're good. Yes, you're good.
you. Ask where we'll get back to you eventually, so.
I was gonna say, we don't necessarily screen ours, but we're not always available, just like everybody else. If
Yeah,
you leave
right.
a message, if you call or send an email, we'll get back to you.
From there, we'll talk.
Right? If I'm there and available and not in the middle of something, I will certainly answer my phone. If you go to the next slide, please, David. So with regard to duty of loyalty, you want to make sure that you're adhering to the conflict of interest. There's not really a policy. There's some statutes that we'll go over in a bit. Don't use your position within the commission as for personal gain. I thought I took that out. Maintain confidentiality, but there's nothing that you guys do that is confidential and we don't go into executive session, so that's less concerning. And then once decisions are made, board members speak as a united voice. And that's from that county board member handbook. It was put out in 2008 as a joint compilation between the Wyoming Association of County Commissioners and UW Extension, which I have a terribly, it used to be bound and somebody ripped the binding off and scanned it. I have the scanned copy of that if anybody would like to see it. And really that goes to, so you're good there. So that, just one second and then I'll let you talk. So that goes to what we'll get into later, which is the majority rule decision. Once a decision is made, that is the decision of the board. Yes.
Yeah, just go back one and for the benefit of our two new members, this point came up several times over the last year at the voice of Commissioner Spiegelberg. Not that that's relevant, but as we move forward from a meeting where we have made a decision, there were very aggressive objections made to a commission member then addressing, say, the county commission with their concerns about a particular topic. So talk to us about how your fourth bullet fits with respect to what we as commissioners proceed following a meeting on issues that we feel strongly about.
So there is nothing in statute that guides that behavior. The analogy that I made last June when we did a similar training was, it is like the Supreme Court, whether it be of the state or the United States Supreme Court. When a decision is made by a board, that is the decision of the board that goes forward back to whoever, but in this case goes forward to the commissioners. In an attempt to address your concerns way back from when we were in June, prior to having the dissenting votes and the motions and a summary of that that used to not be in staff reports. And since our June training, it is in there in an attempt to address that. Again, similar to a court decision. You have a majority opinion and then you have a minority opinion. So it's really, there's no actual guidance. It's more about perception. If you are a member of a board and the majority rules and makes a decision, that is the decision of the board that goes forward. So I think, and not to speak for Mr. Spiegelberg, because he's not here, I think the concern that he raised, and to some extent is a valid concern, is if you have individual board members then approaching the deciding body with a decision outside of the staff report. If the minority vote or the minority opinion wants to include something within a staff report so that it goes with the vote and then there's a minority opinion, that seems, at least in my head, to be a more concise way to do that. But that there's nothing that stops you from doing what you have been doing. And not just you, I don't mean to single you out, but you brought up Mr. Spiegelberg's concern, so that's what I was thinking of. So if there is a board member who wants to approach the commissioners with why they think something has been done incorrectly or things that were not considered, you certainly can. My suggestion would be instead to work with David and Joe to get your concerns addressed as the minority vote information that goes within the commissioner's packet. So then your concerns are addressed and it doesn't look or lessens that objection of doing an end run around a board decision.
All right, no, I appreciate your thoughts on that. And then again, for the benefit of the new commissioners, we have worked on that over the year, and you have suggested a minority report, which prior to that, decisions came forward from the P&Z to the board, just a naked yes, no, and then maybe a vote count, 3-2 or 5-1, which many of us felt, and it sounds like you'd agree, and I think it's obvious that denies the county commissioners the benefit, if there is any, of our discussions and pros and cons and so forth. And so what I'm hearing is an invitation to help these guys do that staff report, because that would be slightly new. As it is, we just left it to Joe and to come up with this minority report. But I'm quite interested to hear your invitation to make that a more formal process. I'm sorry, Commissioner Kennedy, go ahead.
Well, the other thing that has changed in my perception, prior to this last year, we very routinely had the commissioner who was the liaison present at all of the meetings. So there was a commissioner who was had been at the meeting and was informed as to what minority positions were and could relay those to the rest of the commission, so that, you know, it kind of eliminated that that additional burden of doing that. So there was the commission already had someone who had a sense of where the board was and what the various opinions might be when there was something of controversy.
That is true. And I'm not certain who the commissioner appointed to the Planning and Zoning Commission is.
I believe it's Commissioner Richards.
Is it? Okay.
Liaison, I believe.
Yeah. So.
I mean, I'll pipe in my 2 cents. So, I think that was a good addition to the staff report, is to have that discussion, especially if it was not like a unanimous decision, to have the dissenting opinions in there. I guess I would caution on, after that, what we want to put in there is what was said in the meeting. We don't want to add anything after that, if that makes sense. We want to put the understanding what was said in the meeting in that, and I don't think you were meaning to go beyond that, but I just don't want to have people who call up like, well, this is what I wanted to say in there, so this is what I meant to say, you know. We need to go by what was said in the meeting to be accurate of what was discussed at that meeting and not add to it, I guess.
I agree.
So, yeah. And it's, we're kind of picturing here something could become quite cumbersome. Maybe it doesn't come up at all, but, and Joe's done a nice job of trying to gather things up, but often it's a commissioner having asked about blah, 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 blah. Yes, that's true, but, and then maybe that's more relevant to that commissioner than it was to Joe as he was hearing it. So it sounds like we kind of move forward with this, but I think that's a very, and it comes back to my question, why are we here? And what are we doing? And why do we have a planning and zoning commission? And presumably we add some benefit for the county commissioners in vetting proposals and working things out for them. Otherwise, if we're just a duplicate of what they're doing, why bother? Just let them do it. So yeah, let's work as we go forward in trying to capture that important thought in a tractable way, which may be quite a challenge, but thank you.
Know the laws pertaining to your agency. Examine the agency's governing documents. You have them now in front of you. If you didn't already have the bylaws, now you have them. And I know David and Joe have given you all copies of the regulations when you get started. And be informed of the agency requirements. Similarly, just be certain you're aware of what's in your zoning regulations. And if you have questions, be sure to ask. We just went through this. You can, oh wait, well, hold on, sorry. It's a little different. So individual board members don't speak on the board except in limited predetermined cases. So that's somewhat applicable here, but it's more applicable when you have, for example, the commissioners, if there's a contract in front of them, one of the commissioners cannot say, oh, sure, we're going to approve that contract and we're going to do this and we're going to do that outside of the discussion of the commissioners because they don't have that authority and they don't speak for the board as a whole. Okay, you can go forward. Thank you. So then we get to recusal, which is declining to participate in a vote if you have a special interest or relationship that would give the perception or your own judgment that you are not able to make an independent judgment as to what's in front of you without that being influenced by your own personal relationships or interests. So recusal can be detrimental to the board because you're missing a vote of a member who's been appointed to a commission. So it's in limited circumstances where it's always necessary that you recuse yourself, and we'll get to those in a minute. The other circumstances if you have a concern about a conflict, if you're concerned about a perception of a conflict, you're always better off. You ask for disclosures at the start of your meetings, don't you?
Yes.
Then you can disclose. One that comes to mind is with the Roger Canyon LLC land use change or zoning change application. Maura lives across the road in a subdivision. She felt like she was able to vote impartially and fairly, but she did disclose in there. For the record, I do live across the road. I don't think that where I live makes me impartial or unable to vote fairly in this matter, and I will be voting. I'm just disclosing my relationship. Thanks, David. Conflicts of interest. So when you have a conflict of interest, there's 3 general questions that they lay out. And if you have any answer to yes, you may want to abstain. One of those is your interest direct and immediate as opposed to speculative and remote? Like for Maura, a land use change directly across the road, it's not necessarily direct and immediate, or it's not. If she was voting on a land use change for something right next to her house because she was going to build something right there, she would need to recuse herself because she has a direct and immediate interest. The fact that because we'll pick on Keith for a minute. So Keith, you're a lobbyist. Somebody's going to come in
and they want to put in some kind of an agricultural processing facility or some research center or something that is a client of yours, and that requires zoning changes or whatever. That's a direct and immediate, because your client is working on this, you would recuse yourself in that matter and let the rest of the board vote. The second part is, does your interest provide you a greater benefit or a lesser detriment than it does for a large or substantial group of people who are similarly situated? So if your interest is because it is right next to your house and you're the only other house out there, that's maybe a concern. If you're talking about a development that is somewhere else and your concerns are as a whole, that's not a problem. Thank you. And then the interest of impropriety, or the appearance of impropriety. So it's not necessary to consider that, but there is an AG opinion at some point where they said it should be considered to maintain the public's confidence in the integrity of lawmakers. And technically you're not lawmakers because you're advisory, but same theory applies. Conflict of interest. Everybody talks about conflict of interest as though it is this giant thing that affects everybody. It's really not. It's very limited into what actually under the law constitutes a conflict of interest. If you are going to get any money or request any money as a result of your decision, that's a problem, including letting of contracts. If you use your personal gain or your personal potential gain to leverage votes with the rest of your board, that's a problem. And it can be the violation section down there at the bottom. It can be punishable by a civil fine and or a civil contempt misdemeanor matter. And a fine of not more than $5,000. So I just left that in there. So it's in the statute. I always figure we should tell you it is a possibility. The chances of it actually happening have to be pretty darn egregious. You can skip that one. We talked about it already. So this goes back to that basic fairness. Can you make an impartial decision and that avoidance of prejudice? If you have information that's not commonly known that may have an adverse effect, you need to either disclose it or recuse yourself from those votes. We just said that. You can skip that one too. So if it's a personal, if you don't fall under that conflict of interest statute where it's very narrowly tailored, but you feel like personally you can't vote on something for whatever reason, all you have to say is, I am recusing myself from this decision because I feel I can't be impartial. And you don't have to state the reasons for why. So you don't have to get up there and be like, because it's my brother-in-law and I have a whatever. Like, you don't have to spill all of your guts to everybody. We don't need to know. You just need to say that you have a conflict and won't be voting. And ultimately the question you ask yourself is, can I be fair and impartial in my decision making? Ethics. Those are the statutes that relate to ethics. It's under 913. So this is kind of related to conflict of interest, that you don't make an official decision on if you have a personal or private interest in the matter. And then you go through these things again, which apparently have things out of order. I tried to fix it. I didn't do a good job. Direct and immediate, greater benefit to you than it does to the general public who are similarly situated. Next slide. And if those things apply, then this is a shall statute, you shall abstain. These are the red flags as a board member that you want to be careful of, that you don't get into the bribery, nepotism, those kinds of things that can raise problems for board members. You don't want to accept gifts. You don't want to accept compensation. Obviously, if somebody's going to pay you for a vote, it's a big red flag. If you have outside employment, which is incompatible with your
the discharge of your duties and responsibilities, that's a problem. And then the other one is accepting meals, expenses, lodging, or reimbursement of travel or expenses incident to travel from another source. So if there was a project in Northern Albany County and whoever was proposing that project said, hey, I'll give you gas money, you can stay in our Airbnb up there, come up, see what's going on. Don't do it. It's a problem. You could just drive up there yourself, talk to them and drive yourself back. You just can't accept compensation or remuneration from them for doing it.
Jennifer,
Yes,
has there ever been any history
not that I'm aware.
problems of pertaining to these matters with this board?
With this board, not that I'm aware of. I don't think so at all. And really, I only have it up there just so it's not something you have to deal with regularly, but just so you are aware that if there's a problem, let us know.
And like she just mentioned, Mara made that disclosure.
Sure.
I had one a couple of years ago because my next door neighbor was applying to divide the property. And probably Sean made more disclosures than anyone else. Not that there was a direct conflict, but he wanted people to know who he worked for and that they were involved in a project, but he wasn't personally connected to the project. Just so everyone was clear where you were at.
And so that example actually brings up a good example of the direct and immediate as opposed to speculative and remote. Sean worked for Dwayne Toro, and Dwayne was proposing a land use change in potential future subdivision of property out on Roger Canyon Road. Sean's interest as an employee, he's not even an employee, he's an independent contractor, but they all work together, they're realtors. They all work together under, like attorneys, you work together on your own licenses, but so Sean disclosed that he works with Dwayne, but Sean didn't have any immediate interest. He's not partners with Dwayne in that development. He's not invested. He hasn't done any of those things. If it were to be approved and if Dwayne got to the point of ever selling lots, Sean may have the opportunity to sell those lots, but that's a speculative and remote because that's a whole lot of steps in between there that would have to happen that also were not just contingent on this board. So by way of example. So parliamentary procedure, you want your meetings to be conducted in a fair and orderly manner. The bylaws say that we use Robert's Rules of Order, and they're generally just to codify behaviors in meetings. State statutes take precedence over Robert's rules if there's a conflict, and we always have to keep in mind the Public Meetings Act. So Robert's rules, just in general, I am far from an expert, and fortunately, it is the job of the chair, whoever ends up as the chair of the commission, to enforce Robert's rules. In general, consider one matter at a time, majority rules, the minority's right to be heard, which goes back to what we were talking about and including that in what goes to the commissioners, free and impartial debate, timely manner, and courtesy amongst board members and to members of the public who are in front of you. Quorum is a simple majority. On this board, it's 3 out of 5 members have to be present to conduct business. So the board chairs, their job is to assure the board is fulfilling its responsibilities, takes the lead through its tasks, whether it be policies or meetings. Generally, under Robert's rules, you propose an action, and then underneath is an example. You get agreement from at least one other person. Then there's discussion among the board. A second on a motion does not mean the motion's approved. You can second for purposes of discussion. So then there's discussion. If amendments are made, there can be an amendment made to the motion. And then you go down to voting on the action or on the motion. If there's an amendment in that discussion phase, you vote on the amendment first. And whether it passes or fails, then you vote on the underlying motion itself. Parliamentary procedure overseen by the board chair. The board chair doesn't make motions and generally shouldn't second a motion unless no other second is available. And their primary duty is to keep order and keep the meeting running as it should. There are my I can send them to you in clickable link format should you need. Robert's rules, those are the ones I look at when questions come up. So as board members, you generally have immunity from legal liability. So it is a qualified immunity. It's while you're acting within the scope of your duties. If that's the case, the county defends all of those things for you. You can erode that immunity, unethical actions, wrongful purposes, any of those things. Here's the erosion just broken out more into bullets because I forgot to take it out from the other side. Sorry. And then meetings have to be conducted in public. There has to be advance notice, and the meeting minutes have to be made available to the public once they've been approved by the board. So your minutes from January are approved at February. Once they're approved, then they're available to the public. So you have regular meetings, special meetings, and emergency meetings. Work sessions are like special meetings. You have to provide notice of them in the same way. Emergency meetings, you guys shouldn't have any that I can think of. But if you do, it's a very narrow reason for having them. And then it has to be, you have to call a special meeting within 48 hours to ratify the decisions made in an emergency meeting. Opens Meetings Act, just in general, is that citizens have a right to attend public meetings and to know what goes on in your meetings. So the gist of all the things that we do is to make sure that there's not decisions being made outside of when you're all together as a commission, and that the public is aware of when your meetings are so that they can attend if they want. And really the one nice part, or one of the nice parts about all things COVID, is having the ability to attend via Zoom and also having them available on YouTube later. So if somebody can't be present, but they want to know what happened, it's always available to go back and listen. We talked about all of those things. Oh, the public does not have to just attend a meeting. You can't require people to sign in as attendants. Anybody who wants can come and sit. They don't have to tell you who they are. They don't have to do anything. If they want to speak in front of the commission, you can ask them what their name and affiliation is, so that it's part of, and really that's part of your record keeping, so that your minutes are clear about who is speaking, if they're speaking on their own behalf, if they're speaking on behalf of an organization, and then you have to keep minutes. That's the definition of a meeting. Let me skip that one. And then assembly, this is the one that you have to be a little bit more careful of. Only in terms of, you can't use email correspondence between the board as a whole as a way to circumvent a public meeting. And then action means that transaction of official business. So you have to make sure that any actions that you're taking happen upon a vote within a meeting. Again, the penalties. Let me skip that one too. Regular meetings, those generally are within your bylaws. And if you have a regularly set meeting that is in your bylaws and is published, you don't have to publish notice of every regular meeting. If you set a special meeting, or if you change the time and date of your regular meetings, that usually goes through a policies and procedures change or something that gets published so that the community is aware. There is the option of an order of recess. So if you, Rail is a good example. If you, as a commission, if we had something big again, like Rail Tie, or we didn't know it was going to be a big deal, and we come into a meeting as a regularly scheduled meeting, and you have an influx of public comment that you weren't aware of, and you're getting late into the night, and you don't want to cut public comment off because you can always. But if there's discussion of the board or public comment, you can recess that meeting, like at 8 o'clock at night. You can say, we're going to recess this meeting until 8 o'clock tomorrow morning in this same room. We post a notice on the door that says the meeting has been recessed as of 8 p.m. until 8 p.m. tomorrow in this, or 8 a.m. tomorrow in this same room. We have done it on the commissioner's level. When we have had big public comment things, we will do our business meeting in the morning.
recess that meeting until the evening, so we can come back with the idea to allow more people to attend the actual meeting in person after work.
Did you want to talk about that again? Bridge.
What? No, you can skip it.
I went ahead and
It's okay. I appreciate you. Public Records Act. So the public records, for you all, it shouldn't be much of a problem. David keeps all of the things. He keeps track of all of the things that go out to you. So there's not a lot that has to be done there. It can be that if the county were to get subpoenas in a lawsuit or something, it is possible that your correspondence, depending upon what the subpoena said, but amongst board members or other county employee members or regarding a certain something can be discoverable out of your own personal electronic emails, but it has to be very narrowly tailored. Their request has to be. Public records include papers, photographs, film or microfilm form, emails that are sent, like all of our county emails are generally discoverable as public records. Again, there's penalties for violating Public Records Act. And then, as we've talked about throughout the day, is that this board is advisory to the Board of County Commissioners. And so what you guys do is super valuable work because they don't have time to wade through all the intricacies of all of these things. That's why this board is created, or commission is created. And because you all have knowledge of certain things, or the idea is you have knowledge of certain things that are valuable to land use regulation, all of that within Albany County. So this board does really all the heavy lifting and then presents their recommendation and all of their findings to the county commissioners, who then ultimately make the final decision.
I got you.
I know that's okay. That's the last one. And then the updates and staff report as a whole are just that we have started updating staff reports. We did, which one did we do? Land use, zoning? Conditional use?
Conditional use.
We did conditional use. We're working on updating the subdivision staff report now. We'll get through all of them. It just takes a while between our office and David to make sure it's in a format because, you know, as attorneys, I'm always like, no, we need all of the things, David, all the things. And David's like, I don't want 20 pages of staff report. Nobody's gonna read that. So we're working on it. David's looking out for your best interest and not making you have to read every word I think should be in there. So does anybody have any questions for me or Matt or anybody? Yes.
Yeah, there were a couple of just areas that I had hoped we would get to. I don't know what our time frame is, but I guess we're getting pretty close to the end. One speaks to what you just went through, communications amongst ourselves.
Mm-hmm.
And so talk to us a little bit about that. Can I call Keith and he can convince me of like trying that wrong, or is that out of line? Or
Give me a bite at the apple first.
how do we do that?
First of all, there's the quorum rule.
Yes,
So
that's important.
you and I can talk, he and I can talk, but the three of us can't talk about a decision that's upcoming or that we've made.
Not all at the same time.
Not at the same
That's
time.
me.
Yeah.
Yes.
And that goes to how you communicate with each other too.
Mhm.
One of the things that I've been told in meetings with the Attorney General with a state board that I work with is I have to use the state email that is assigned me because that's all public record.
Correct.
Unless there's some part of that is exempt, and there's a whole list of stuff in there. But the other thing was that they recommended that when I emailed all those commissioners, anything about a decision other than just like, here's the meeting time, here's the resolution you guys adopted, that I do at BCC so that they do not know that there's anyone besides me corresponding with them, and they don't have.
And you can't reply all
You can't
accidentally.
reply all to BCC either. So that way there's never that influence or idea that you can communicate and make a decision together.
Okay, but if you wanted to, you had seen, but I gave you guys an example in here. If I wanted to share with my colleagues some documents that I thought were relevant to what we were doing, am I welcome to do that?
Do it, but so put everybody that you're sending it to with like the
I
exception of
think the better
David and
method
Joe.
would be if you could ask David
Yeah.
to send it out,
Yeah.
since he's not a commission member.
Right.
Yeah.
David can send it out to everybody, or if it's something that it's urgent and you need to do,
Okay.
then just put everybody's email in as a BCC email. But you have to be a little careful then too, that you don't get into discussions with everybody where information is being shared all around, because then you're circumventing public meeting.
Well, all right, the real example is at one of our meetings last year, Commissioner Spiegelberg asked me a very specific question.
Mhm.
And I answered as best I could on the spot, but I'm not the sharpest pencil in the pack, and I like to organize my thoughts. So then I sent out a response to all the members afterwards,
Mhm.
detailing my answer. He took strong exception to that, just because he objected to make it wrong. Was that in some way non-transparent as far as our obligation to the public?
It's a little tougher because you addressed it to all of the commission members as a whole, because then it's not in the meeting minutes. It's not in those types of things. So,
And from a personal viewpoint, that it also opens you up to someone asking for that public record and then and going through all of your emails for a public records request isn't a blast.
oh, I will tell you, it is not. And then not only then do you have to go through all of them, you have to provide them to the attorney's office, and then we have to go through all of them to see what can be disclosed, what can be disclosed with redaction, what can't be disclosed. It's a mess.
Okay, so, but if we want to do that, let me say, Jeff, or anybody on this wants to follow up on a topic of discussion, they could send it to David.
Yeah.
With that,
Mhm.
get it.
Yeah.
I'm not trying to avoid anything, but get it into
Yeah.
the realm, but to give us the option of communicating with each other outside the meetings. I mean, nobody likes to be in a meeting forever, and there's lots of stuff that we can usefully say to one another outside the meeting. So the suggestion here would be invite it to David and ask him to distribute it.
As a limited option, yes, it should not be something that is exercised regularly.
I mean, you could do that too, and if it wasn't like you wanted it immediately, then anybody could send me a response, and I could put it in the next packet.
As an agenda
You know,
item.
or even as an agenda item, or just for your reference here, Mr. Hinckley put this in the packet, so you can look at it,
And perhaps that'd be better for your letter. I think that like sharing resources is probably, I don't think that's so much in the spirit of, the public business.
Okay.
So like when you have the
But-
studies and the things like that David just sent out last week or
Yeah.
early this week, whenever that was. Sending those out with a BCC with everybody BCC to just say, I found this study, I wanted to make sure you had all seen it. Great.
And the packet at the county commission level, but packets get quite long, but it's just electrons in this day and age, correspondence received and information, and I find that useful. Is that faithful to this idea of the public gets to see what we're up to?
Yeah, because then those packets stay around.
Okay, okay.
They're accessible
Their
on
own website.
the website.
And the one thing I would point out to you is most of the time, the correspondence in those packets is not initiated by a commissioner. It might be responded to by a commissioner, but it is not initiated by a commissioner in the majority of cases. There are times that it is.
Okay. The other general topic, and we're going to get very far with it, maybe we'll just have to take it one by one as we proceed through the year, was this concept of decision latitude. And that's critical to what we're doing. For example, last 2 years ago, Mr. McKinney brought forward a subdivision request. It was zoned rural residential, I guess. 5-acre lots just on East Grand. The city weighed in quite heavily against it, saying, "Oh no, it's contrary to comprehensive plan and all these other things." And the answer from the county, I thought quite credibly, was, this guy's in a zone that says 5 acres is the minimum lot size. I'm at 5 acres minimum lot size. I don't care whether you like it or not. I thought that was a nice example of, and I thought the county was absolutely right. We all hate it. It's not the stupidest thing ever. He met the requirements. And so in that case, there was no latitude. We couldn't say we approved this with 7-acre lots. Okay. However, we are constantly coming up against, say, a neighbor comes in and says, well, I don't like this. There's not enough parking. Or Game and Fish says we want wildlife friendly fences. So what I'm searching for, and maybe there isn't a generic answer, is when we approve a subdivision or a zoning change or anything else, how much of it is just clerical? They met the requirements, here they are. David processed it all, Joe confirmed it, you're done, why is it even in front of us? Versus us bringing our varied backgrounds to bear on it, say, here are the conditions. Covenants in a subdivision is another great example of this. So a broad topic, but what kind of guidance can you provide us in terms of our latitude in deciding and conditioning our decisions as we move forward into this next year?
Oh, conditional use permits are always nice because that expressly allows conditions.
Right. And it depends upon the language of the resolution.
Yeah.
In what section you're looking at, because some of them say what's necessary for approval is the applicant has done X, Y, and Z. That is a yes, it's done, no, it's not done. There are some that say that the applicant has submitted information, sufficient information to address the following, or evidence to address the following. And then there's a whole list of criteria. It doesn't say they have to absolutely mitigate all of the following. But the sufficient evidence is a discretionary decision of the board.
So can I just add, that I see, like, so we'll get responses from DEQ or Department of Transportation or Game and Fish. Now, as long as we can tie what they're asking for with our regulations, then I think we can apply those things that we think are important. Just look, if we look in our, I think it's under the planning considerations in the subdivision regulations, we do have latitude to require things or whatever that have to do with wildlife. It mentions that in our subdivision regulations. So we get something from Game and Fish that says, you know, this is where all the mule deer are coming to winter, and if we put a subdivision here, it's going to kill them all off. And if you go forward, then maybe there's these mitigation efforts that you would want to do that would help this herd or whatever. We can implement those because there's a regulation in there. So we just have to tie it to something that's in our regulations. And a lot of the things that we get recommendations are, we can tie back. It's just a matter of finding that little provision to tie it to.
And when you're talking about covenants, the one that comes to my mind is specifically the wild horse covenants that were addressed. Those were existing covenants that are recorded in the land records office. So they are not speculative and remote. They are not subject to change without the provisions set forth in there. So those covenants, while they are a civil application of things, they are something that this board can consider because it is like an easement or anything else that runs with the land once it's recorded.
But one could not make those covenants a condition of the approval. Is that right?
Their covenants are a requirement for subdivisions within the county, aren't they?
Yes.
Yes.
That you have to have covenants.
Yes.
But again, trying to find the edges of that envelope. Say they covenanted, nobody gets to paint their house purple. we could then say, we approve this conditioned on the fact that nobody paints their house purple?
No,
I would think not.
no,
So,
because it's not that's not a recorded document.
Well, if it were recorded in their covenants, I mean, they'd all agreed amongst themselves.
But what what is presented to you is proposed covenants that haven't been recorded because a subdivision hasn't happened. They can present them to you in one form. And our requirement is that they have covenants that address roads, open space, something else.
Like utility or something. I can't remember, but
I
it's
can't remember.
those basics.
It's those basic things. So long as what they present to us has those basic things in there, that's where our regulation stops. If a developer, so long as they present us a draft that shows that, great.
So that's.
They could have 9 million other things in there. We can't.
Do you have the wildlife fencing in mind?
No, I mean, just in general, like what I just heard this description, that would be a checkbox. Either have
Yes.
covenants or don't they? Okay.
Do you have covenants that address
That address
these
these
things?
But that's where Joe would take care of that. There's no discretion for us. There's no latitude. We don't get to argue with their covenants or anything. So that's what I'm fishing for, is where do we have discretion as decision makers? And I guess we depend on our staff report just to identify those for us.
And
And maybe that's my plea, is let's try to be,
Well,
each
and-
time these come forward, tell us what's just check, and what is truly discretion.
which is also fair, but it's also in your resolution. It's in the zoning resolution, which you're expected to understand that zoning resolution when something is in front of you. So if you have questions before you get to a meeting, after you've looked at the zoning resolution, you've looked at the application and you can't reconcile it in your head, that's when you address questions to staff prior to a meeting. Because if we can address those prior to a meeting, it's not something that needs brought up in the meeting as a whole. The meetings run more efficiently.
Sure.
So, I mean, so that's what I would say. The expectation is that each one of you knows, or at least knows how to find in the resolution, the section of it that applies to whatever application is in front of you. And you have the staff report to help guide you. Then you can look at the language in it. Is it an absolute? Is it something that says sufficient evidence?
Yeah.
And we don't have a definition of sufficient evidence.
There's something like, have they adequately addressed traffic? Somebody has to decide whether their address to traffic is adequate or not.
So that goes back to, though, if you are, so David sends it all out to YDOT to review, right? If YDOT and County Road and Bridge come back and say, we don't have an issue, the creation of this subdivision or whatever it's going to be, we've looked at what you're proposing, what we know about our roads and our things now. We do not have an issue with this subdivision going in. It's not going to cause us increased maintenance. Or YDOT comes back and says, where you're putting this subdivision further out, you only have one access road. The amount of traffic on that road is too much. There now has to be a stoplight or a stop sign. Once you have recommendations from the state agency and the county agency that are the agencies responsible for those things, it's pretty tough to say my judgment as an individual overrides the state and county decision makers who are in charge of making these decisions.
And that's a great example, because we dealt with that with one of the subdivisions in November, because we had a lot of public comment about traffic conditions
Correct.
on the state highway, where we had a recommendation from the highway department that it did not present an issue.
Right. And the other part you have to consider is the state agency or county agency that's making that decision is making it based off of whatever their metrics are. When you have neighbors, they're basing it off of a very personal, emotional response. Sometimes there's valid points, like we have a lot of traffic, this corner is too sharp, putting more traffic out there, whatever. You can consider that, but you have to be able as a commission to remove the emotional component of it and say, factually and logically, what is this? And does it meet what our regulations say it needs to meet?
Yeah, no, it's inevitably going to become a little bit fuzzy, but I just want us to keep in mind that we do have some latitude. Say Commissioner Fine, as a geochemist, comes to us and says, oh, what about this? And then we as commissioners could say, we reject this application based on blah, blah, blah. And I think that's the critical piece of the story, is that you have that latitude if you can articulate good reasons for exercising.
Correct.
Fair.
And then just from our standpoint, ultimately the question becomes, if it gets denied for that, a very specific requirement, the appeal is always going to be that the decision was arbitrary and capricious. So then it's going to go, we're going to argue that it's not, if that's the decision that's been made, or that it was, if it's a denial. And then the opposing side is going to say, no, it was absolutely arbitrary because they did these things. Then it becomes up to the court to decide what is arbitrary and capricious, because there is some case law, but there's not a lot.
Okay, it's a general discussion that will go on as we see individual applications, and there are those long lists of wildlife, and environment, traffic, and then but we are authorized to make those findings. We're required affirmatively to make those findings based on the evidence, knowledge that we bring to the table.
Correct.
Thank you.
Anything, do you have any other questions?
We could go on and on, but I'm prepared to stand out for the moment where we're trying to wrap this up.
I was gonna say, I think our official meeting is at 5. So if we want to wrap this up now, give everybody just under an hour break to come back. Okay.
Thank you.
Thank you all. We appreciate
Thank you for
it.
the presentation.
Much appreciated, Counselor.
Thank you.
Can we take the bar exam now? Get in there.
Don't do it. It's a trap.
That's it.
Right.
All right, gentlemen, I assume we reconvene at 5.
Yeah, we'll reconvene at 5, and there's a different Zoom link for the next meeting. So
Yeah, it's.
That what I printed out for you is a printout of a section of that.
I don't even use.
yeah, when I send an email, it has both of them.
Sometimes I do. I like to be able to touch it and flip back and forth.
Yeah,
I'm also.
I can't remember when the Green Book was and of course, there had to be a supplement. 2021, or is this a new set?
2021 is new.
Okay.
I don't really understand how they publish this, to be honest. Because then there's always also a supplement.
Yeah, well, they always do. Let's see.
I don't know if the supplement just follows like budget sessions.
I don't know why, but I think it's just.
It's endless.
I think it's 2. I think my last ones were 19. You get a supplement in the middle. It's every year that they have not a budget year, legislative year.
Okay, because I don't know why, and maybe it's just because everybody's been cheap, because I think they have to publish a supplement.
You get a supplement on the in between years, and you can get a supplement going on
Yeah,
as
and I
well.
think
My question in my mind.
They're really
Necessary for
expensive.
approval. Oh, yeah, because that's what,
Every 4 years.
so that's what,
They're really expensive
Yeah.
as well.
we've been getting challenged
Are you
on.
hanging out here?
I am hanging out in here. I need to write a letter for Jeff
Necessary, but
that needs to go out
Any of these
tomorrow.
things, if we say no, it's
So
bad
I'm just gonna
idea.
have to.
So that's
whatever
what-
you
yeah,
I'm
want
gonna
me
leave
to
it
do.
back there. It's gonna
No,
secure and I
Sure.
just don't want.
No, I'll
really
I'll be
what
here.
the,
Yep.
That's easier and quicker to load and.
the basis for, I think, like a recommendation
Green Book.
should be tied to is the findings necessary for approval are essentially just.
But if P and Z says no, the county commission can still say yes.
Because it is just directed.
But just keying on that language, that both must find the applicant.
Yeah. So each board has to make their own findings. So the
Nobody
commissioners,
cares what we, I mean, ultimately.
well, but really though, what comes out of P and Z
No.
is the basis, at least